10th time ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ ಅಂತ 10th ಟೈಮ್ ಬಂದ್ರೆ ನಾನೇ ಓಪನ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಮಾಡ್ಕೊತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಹೌದು ಇಲ್ಲ ಕೋರ್ಟಲ್ನಾಗ ಫಸ್ಟ್ ಮಾಡ್ಬೋದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅದ ಏನು ಹೇಳ್ಬೇಕು ಇಲ್ಲಿ ಹೇಳೋದು ಇಲ್ಲ ಹಿಂಗದ ಏನದ ಅಂತ ನನಗೆ ಹೇಳೋದು ಇಲ್ಲ ಅಂದ್ರೆ ಏನು ಕಳಿಸ್ಬೇಕು ಮಾತಾಡೋದು ನೀವು ಫೋನ್ ಕೊಟ್ಟಲ್ಲಿ ಕೈಯಾಗ ಕೊಡಿ. 10th ಟೈಮ್ ಅದ ಮುಂಜಾನೆ ಬಂದು ಹಿಂಗದ ಏನದ ಏನು ಮಾಡಿ ಹೇಳ್ಬೇಕು ಅನ್ನೋದು ಒಂದು ಸ್ವಲ್ಪ ಕಲ್ಪಿಸಿ ಬೇಡ ಏನು ಮಾಡ್ಬೇಕು ಈಗ ಅದ್ರಾಗ ನೀವು ಬಂದು ಒಂದು ಫೋನ್ ಮಾಡ್ಬೇಕು ಫೋನ್ ನಂಬರ್ ಅದಲ್ಲ. ಹ್ಞೂ ನನ್ನ ಹೇಳ್ಬೇಕು ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಆಫೀಸ್ ವೆರಿಫೈ ಒಂದು ಸ್ವಲ್ಪ ದಯಮಾಡಿ ಒಂದು ಸ್ವಲ್ಪ ಒಂದು ಫೋನ್ ಮಾಡೋಣ ಎಲ್ಲ ಪಿಲ್ಲ ಪ್ರಶ್ನೆ ಆಯ್ತು.
ಮೇಡಮ್ ಮೆಮೋಗಳಿಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ಏನ್ ಹಾಗೆ ತಗೋತೀರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಲ್ಯೂಮ್ ಇಲ್ಲ ತಮ್ದು. ಮ್ಯೂಟ್ ಆಗಿದೆ.
ಹೇಳಿ ಸರ್.
ಮೆಮೋಗಳು ಕೊಡುವಾಗ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕೇನ್ ಹಾಗೆ ತಗೋತಾ ಇರೋದು?
ಸರ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡ್ರಿ ಸರ್.
ಸರಿ ಸರ್. ಅಂದ್ರೆ ಕೊಟ್ರೆ ಯಾವಾಗ ಆಗೋದು? ಅಂದ್ರೆ ಡೇಟ್ ಕೊಟ್ಟಾಗ
ಸ್ಲಾಟ್ ನೋಡ್ಬಿಟ್ಟು ಹಾಕ್ತಾರ ಸರ್. 2-3 days ದಲ್ಲಿ ಹಾಕ್ತಾರ ಸರ್.
ಸರಿ ಸರಿ. With leave of the court, my lords, memo for posting, my lords, there is a mandamus.
ಕೊಡಿ.
Yes, my lords.
ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮಾಡ್ತೀನಿ ಫಾರ್ ರೆಫರಿಂಗ್ ಟು ಮೀಡಿಯೇಷನ್. ಇಲ್ಲಿಗೆ ಯಾವಾಗ ಬರ್ತದೆ? ಹೇಳಿಲ್ಲ ಮಂಡೇ. ಹೇಳಿಲ್ಲ ಅಂತ ಅವಾಗ
7 to 14, page number 4, December 15 to 19, page number 5, December 22.
Lordship, in this matter, next week might be taken up, my lordship. Other different advocates for different accused are there. So some of the advocates are not ready.
No, that is not our concern. You have to be ready. That you have to talk. You have to have a joint meeting of all the council.
And we will fix a date.
So we will not wait for everybody to come. We will start one by one. That is their headache. 10 years, if a person is in jail.
Yes.
What is the purpose if lawyers take time? Don't misunderstand.
I understand, my lord.
Why we have prepared this list of seniority of sentence? Because we feel, suppose for 10 years he is and we acquit it. Don't you feel, we feel little uncomfortable that why should the case have been there for 10 years?
Please, I understand, my lord.
So your conscience also, you also feel uncomfortable.
I will discuss with the other councils and we'll start, my lord.
So you be ready, Monday will be ready.
Monday, please. I will inform the other.
But when there are different council, you must all sit together.
Please, yesterday we had a talk. So we'll,
so
from Monday we will.
If you discuss amongst yourself what is the common grounds to be raised, etc., it will be good for all of you also and convenient for the court. Try to prepare a synopsis also.
Yeah, pre-conviction custody is not considered in this sentence, my lord. That is also pre-conviction. Before sentence, they were in judicial custody. That is not considered.
How much time he was there?
I think almost 2.5 years.
My God.
So in
Then-
another 1 year, so 14 years.
No,
13.
we won't wait till.
Monday,
14.
my lordship, I will discuss with the other councils
Yes,
and
yes.
we'll start on Monday.
Our conscience pricks and so must yours.
It was, first it was registered as a MLC as a motor vehicle accident, then it was brought into a 3-0.
Prepare synopsis also.
I already filed, my lordship.
Good, good.
I already filed. It is
So
on
you have a
record.
joint meeting, get ready.
Please, much obliged, Monday.
Non-compliance of office objection.
My lord, on submission, serial number 20 and 26, my lord, I had mentioned yesterday to take the matter on 15th, my lord, coming physically. It's listed. 20 and 26. Obliged. my lord.
Yes,
My lord, I have got a submission to make in this case. This is a matter wherein Karnataka Administrative Tribunal.
It is
The compa-
compliant, it is compliant, madam, office to verify. It will be taken next week.
complied.
Yes, madam.
AGA submits. AGA submits, office objections are complied with. Office to verify and list the matter. Next week, date could. 17.
Much.
BK nine.
Yes,
To appear
yes,
for the-
Lord, I may be permitted to appear, my lord, through video conference. my lord.
yes, yes.
Second matter, my lord, I complied the, my lord, direction of this learned single judge. I filed the, my lord, affidavit along with the documents.
My lord, affidavit has been served at 10:30 today. My client is here. I will verify. Have it on Wednesday, my lord, so that I will make.
Relist on Wednesday. Yes,
Right.
Already.
Lord, it's for postal information, Lord, it is served, Lord.
conversation. Respondent number 1.
One,
Yavat Sarvai.
third on 31st,
The postal tracking report reveals that notice to R1 has been served. Office to show the name of R1 as served in the cause list. Relist the matter. We'll have it next week. You
Yes.
start on the
yes, yes.
relist the matter on date good. What is the election matter? What is the election?
Election is, my lord, the Gram Panchayati election who was elected has been set aside on the ground of 2-3 grounds, my lord. One is disqualification, holding that he is holding a office of to profit.
Profit.
And another is under the Representations of the People's Act, Section 9A. And my lord, I am also now come across that my lord, the 343 of of the Constitution, where is how it is defined, whether it is the central government or the state government, whether that act applies to us or not.
Get
And-
ready.
All that issues are there.
Get ready.
Though, my lord, the election, that entire period is over, but still the law, in my view, is wrong.
Let us see. Let us,
That's the only issue.
let us.
Ravi B. Patil.
Lord, in this matter, my lord, matter is settled before the mediation center, my lord. Only thing, my lord, we have to file the, my lord,
Last occasion, due to indulgence of your lordship, my lord, this matter was referred to mediation because we are the land losers, my lord, having lost our lands. Then your lordship felt that these are also matters which could be mediated and, my lord, settled. And with the due effort of, my lord, the mediator, my lord, we have arrived at a common, my lord, price over which, my lord, they have agreed to, my lord, take the lands. Now, my lord, one difficulty is, my lord, the beneficiary is the Nigam, Niravari Nigam, who is not a party either in the writ petition or in the contempt proceedings. And the amount is to be paid by, my lord, the beneficiaries. Though SLO is a formally party before this court. My lord, if I am permitted formally, I will make an application to bring them on
No,
record.
but in contempt, we can't. impede
Yes,
them.
my lord, that is the difficulty. Now, however, my lord, the acquiring authority, my lord, being land acquisition officer, who is a party, they can, my lord, make arrangement and, my lord, then they can claim
That
it
you
from the.
discussed amongst yourselves.
Yes, he was present before, my lord, before the mediator at the time
Correct.
of
So you
discussion.
suggest what is to be done. We will then take note of it and drop the proceedings.
my lord, then now, my lord, the compensation is agreed to be paid at 13 lakhs per acre.
Hmm.
If some date is fixed, my lord, let them come up with a, my lord, valid proposal, and we will file a compromise petition and, my lord, entire.
Compromise in the sense, I will only say draft. I'll take note of
Yes.
whatever has been done. We will take note that as compliance of the order, and then drop the procedure.
Otherwise, it could be placed before the mediation.
No, correct. The only problem is contempt, isn't it?
House.
So finally.
Later on,
we
it could be dropped, my lord, by recording, my lord, the compromise before, my lord, the
Hmm.
Lokadala, which is about to be held before your lordship. Ali record ಮಾಡ್ಬಿಟ್ಟು, then contempt could be dropped.
So what do you say, government advocate?
Lord, that is, my lord, that 11 lakhs rupees, some amount is fixed, my lord. Both are agreed, my lord. Only, my lord, that we have to pay that amount through the beneficiary. We also issued a letter to the beneficiary. So that will be payable, my lord. Formally, my lord, we get the, my lord, approval from the department. That's all.
No, correct. So what both of you do, individually you file your memos, affirming to whatever has happened, individual memos.
Please.
We will take note of it and say there is no willful and drop the procedure.
But if that compromise is not recorded before the
So
authority,
we will,
they won't be able to.
we will take note of the undertaking and record it. So you say what has been agreed, you put it separately as a unilateral memo. Let the government file the unilateral memo. We'll recognize it. And
But,
then,
otherwise, if I am permitted to, before Brahat Lokadala, matter is
so
posted.
contempt, that's the problem. It may not look nice. Though
Contempt need not be, my lord.
Then how we can?
Even for pre-mediation stage also, my lord, it could be settled.
So you
Adanna
file the-
refer ಮಾಡಿ.
Correct. You first file your memos. I'll see.
Please, please.
You file your individual memos by the next date.
ಯಾಕಂದ್ರೆ ಅಷ್ಟಕ್ಕೆ ಬಿಟ್ಬಿಟ್ರೆ again it will be, my lord, stuck
That's
in, my
so
lord,
you
some.
file it. We'll see what is to be.
Please, please.
Relist the matter on date.
20th, my lord, you lordship have 20th, my lord.
28th May.
20th.
Please, great.
Five. Narayan Patil.
Lord, in this matter, my lord, we have to pay the, my lord, 2 months salary to him, my lord. That is 1,08,000 rupees. We sent to the, my lord, for getting the approval, my lord. Lordship have it, my lord, 2 weeks, my lord, we'll pay that amount and report to this. Otherwise, your lordship not take in my submission, my lord, and lordship may close it, my lord. That is.
No, no.
That letter is with my colleague, my lord. That letter. That
no, no.
letter is, my lord, is already sent that amount, admitted amount.
Correct. We'll accept you, but let there be complete compliance. We'll give a
Please,
date.
my lord, after 2 weeks, my lord, any date.
Government advocates submits that compliance would be complete by the next date. Relist the matter on date.
23rd, your lordship, my lord.
23rd.
Please,
Yes.
grateful.
Number 6, Prashant B.
Ma'am, the petitioner, my lord, I have filed this IA for early hearing. Matter relates to discharge of the petitioner from service after lapse of 12 years, my lord. The ground is, my lord, the ground is that he has not submitted the proposal seeking declaration of probation. There is no such provision under the rules, my lord, that government servant has to submit a proposal.
Yes, state, you get ready by the next date. You file your synopsis, we'll take it up on the next date.
Please.
File your synopsis. Relist the matter on date. Yes. 21st. Yes.
Please.
Bill number 7, Ravi P. Patil.
11 days in preparing appeal.
Notice is served.
Yes.
On all.
Yes.
What about Narsa Reddy? Notice on Narsa
Yes,
Reddy?
Narsa Reddy, my lord, is dead. He is represented through Srinivas Reddy. Earlier, Buggappa was, my lord, on record before the land tribunal.
Why don't you serve counsel appearing in the writ proceedings? We'll have it next week.
Please,
He's
my lord, in fact, my lord,
he's a local advocate.
Santosh Belamgi, my lord, I had served him the copy, but he said he has also no instructions, my lord, from his client. And Madidini one set copy, sir, Madi. Santosh Belamgi.
If you were to decide on merits,
I'll, sir, one more set, my lord.
the appellant is permitted to serve learned counsel Santosh R. Belamagi, who has appeared in the writ proceedings for the fourth respondent. Office to show the name of said counsel as representing respondent 41A for the present. Relist the matter on.
Formally, if delay could be condoned.
Relist the matter on the next tables.
Please.
Sachin Mahajan,
Kindly issue notice to the respondent.
She so and so Manjunatha Mallayya Shetty is directed to take notice for respond number 2. Shri Shivananda Patil is directed to take notice for respond number 4. Issue notice against respond number 1 and 2. 1 and 2. But then delay earlier. Notify after re-notify after 2 weeks.
Please,
In the meantime, registry is directed to secure the PCR. 2 weeks better. Re-notify on 29/1.
number 9, government advocate.
This will be taken after 2 weeks, my lord, by mistake, by mentioning wrong MFN number, this was posted. The AG has to appear in this matter, therefore it will be taken after 2 weeks, my lord.
Enhancement.
Enhancement.
This is my lords.
Now,
In similar
against
matters-
the enhancement.
In similar matters, my lords, already this honorable court, my lords, permitted to withdraw 50% of the amount. And whereas the delay more than 60 days, that matters, my lords, delay kept open. And liberty to file, liberty to, my lords, withdraw the amount, my lords, with claimants.
What is the submission?
That is a,
It is, my
With my
lord.
lord's kind permission, my lords,
Yes.
please, my lords, I appear for the respondent state. My lords, though the learned advocate general has been instructed to appear in this matter because it's listed, my lords, I pray leave the court to make a submission. My lords, may I draw my lord's kind attention to the order passed by this honorable court on last date, my lords, 16th December 2024.
No, that's okay. In case the advocate general is coming, we'll fix a date. On that date,
Please.
it must go ahead. You tell us which date, we'll fix a date.
After 2 weeks, my lords, please.
Date coding. Let us see. No. Relist. 21st.
Much, please,
It's a, Note on. Yes.
much obliged.
Sachin Mahajan, Sachin Mahajan,
may I kindly issue notice to the respondent number 1 and 2.
P. Sachin, Sanjay M. Joshi is directed to take notice for respond number 2. Respond number 2. Issue notice to respond number 1. Respond number 1. Re-notify after 2 weeks. In the meantime, registry is directed to secure the trial protocol.
Please.
Preliminary hearing matter, serial number 11, Harshavardhan Madipati.
Your Lordship, this contempt petition arises out of the conduct of the accused number 1 in not complying the directions of the learned single judge in writ petition number 200606 of 24.
Direction.
Your Lordship, the learned single judge has directed the respondent number 1 in the writ petition to consider the representation of the petitioner. Your Lordship, the respondent number 1 was the Assistant Commissioner Indi Taluka.
First accused. AG is directed to accept notice for the second respondent. Relist the matter on.
My lord, in addition to. Notice and tag.
Yes.
My lord, in addition to I taking it, let the notices of court.
Correct.
Please.
For the formal respondent, you are
Please.
taking.
Obliged.
Sandeep Vijay Kumar Patil.
Matter is settled. It's an appeal by the owner. Matter is settled before the execution court. Counsel for petitioner is not available. He is out of station. It may be had on 16th or 17th. Formally we report.
No, if it is settled,
Yes.
then we can close it.
My submission, if could be recorded, ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದು appeal ಇದೆ ಅಂತ ನಾನು.
ಅಲ್ಲ ತಾವು ಹೇಳಿದ್ರಿ.
I am for the respondent.
Third counsel. Third counsel for respondent 1 to 5 submits that the claim of the claimant was, which was pending in the execution proceedings has been settled.
Yes.
In light of said submission, no, but he is seeking what for? He has challenged.
He has challenged that order. That is the reason. Let that submission.
But relist the matter on 17th.
Obliged.
In the orders list. Adin badidu. Settle full stop. For the say of the appellant, list the matter in the orders list on. Yes.
Shivakumar Kallu.
For the appellant in this case, my lord, this is appointment on compassionate ground, my lord. My lord,
how many years delay?
My lord, only not more than 1 year, my lord.
No, correct.
Kindly have a look at.
Death is 1986.
Correct, my lord.
Then?
My lord, within 1 year.
No, that may be so.
Yes, ma'am.
But the latest judgment of Justice, I will give it to the court officer. You have a look at it. It has made a summary of all the legal position.
Correct.
And have recorded clearly that the compassionate appointment is only to tide over that crisis. Now, if the death is in 86, you have long crossed that stage, though you may not be responsible for the delay. And then court has said that there is no purpose of considering claim at that stage. I'll give the judgment to the court officer. We'll have it on Monday.
Okay.
2023 SEC online 291.
Though you may not, though we are with you on the fact that you may not be responsible for the delay, but if you say 86, then it's more than 20 years. 30 years, almost 30 years.
In the year 1986, my father has expired. Within 1 year, my mother gave a representation stating that
there's no fault with yours. We agree to that extent. But this is a alternate, it's a right, it's an exception to general recruitment. So we can't honor it up to so many years. But if we find that the state is lethargic in considering your claim, at the most, there may be some cost on the other side. But you may not be able to get relief. Have a look at the judgment of Monday.
in the notification, it is categorically mentioned that within 1 year of attaining majority, the application should be filed. So as per that, I have filed the application within 1 year of attaining majority, my lord.
There's an element of discretion in that, right? You can't give it at this. No, we don't know what is
My
the
lord,
change in circumstances.
Page number 291. Yeah,
Huh?
SCC online 223.
291.
291.
One.
please.
291.
Now, when father died,
In the year 1986.
now where are we now? We are more than 25 years after that. What are you doing now?
Well, my lord, now I am unemployed, my lord.
Correct, but you shouldn't have remained unemployed for 25 years.
My lord, as per the notification.
Monday.
Grateful.
Have a look at it.
Grateful.
Your lordship have it on Wednesday, my lord, not Monday, my lord. Wednesday, my lord.
Wednesday.
Please, my lord. Grateful.
Number 40. Is it parallel?
And a question. Yes. Chamber judgment. Now the Tej Prakash Patak.
Yes, no, that is
the latest one.
Yes, the latest is now that no rule can be changed in the mid or even after that. That's confirmed. It was heard by your lordship on the.
No, we'll hear the fresh. Yes.
The Manipur case, my lord, it is.
No, correct. That latest reference also, no? The Tej Prakash Patak.
Yes.
Yes, Tej Prakash Patil.
Latest one.
Yes.
The latest one then.
Tej Prakash Patak was a Rajasthan High Court. Yes.
Adana, that was.
That larger reference also is answered, no?
Yes, your lord. Yes.
Latest have the then. Reference is answered.
Reference is
answered.
Answered.
We'll get that judgment, your lord.
No, correct. So now, what is your position?
I am the selected candidate, your lord. It has been more than 10 years, your lord. I have been rendering my service.
So they are making it virtually infructuous by taking it beyond certain.
Your lordship, it is not a case. Your lordship.
No, if the case is made out in law,
yes,
we will see how to protect him also.
Yes.
Correct.
So that judgment I'll give it to the court officer. Just have a look at it.
Yes.
Now, who appears for the employer?
I'm parties want to engage kindly short it may be given.
Tuesday, Wednesday.
Much of it.
Wednesday.
And my lord, in the last occasion, my lord, your lordship, in the earlier, my lord, when you're sitting, my lord, directed them to produce. There is another issue. The interview is to be called in the 1:5 ratio. My objection was that it is doubtful because they are not giving any information whether he fits into the 1:5 ratio to call for the interview and give a highest marks of 30.
Okay, 1 nimsha file kodi. Now you tell us at what stage this change was effective?
Change was not after the notification, before the return and in between the change.
Notification was 3/8/2012, your lord. 3/8/2012. And the early change is on 22/8.
Short synopsis I have given. Notification was on 3/8/2012.
Synopsis filed on?
Filed on Lord 14/8 or 24.
Notification is 3/8.
Yes.
And in the notification, interview marks is settled or no?
No,
No.
No.
It was kept open.
yes. No, my lord, interview marks under the rules notification, it was 5. In the notification, they did not notify it how much marks will be for the interview.
No, just one. So the rule applicable as on that date,
Is 5 marks.
rules of
Yes,
recruitment,
yes, it's 5 marks.
5 marks. Okay.
By virtue of introduction in 2030, the new rule,
2000, so the new rule was made when
2013, 22/8/2013,
22,
August 2013.
at the list of dates alilla, 2013.
Yes, sir.
New rules came.
Yes, sir.
And as per those rules, the interview marks was changed from 5 to
15%. 15%.
5 to 15%.
Yes.
From 5% to 15%.
ಇಲ್ಲ 5% ಅಲ್ಲ, ಅದು 5 ಮಾರ್ಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲಿ. It was only 5 marks.
And then it was changed to 15%.
15%. And my lord, by following the very same notification in the rest of the, my lord, so district central cooperative bank, they followed 15 marks, not the 15%. Because there is a, my lord, the whole marks secured in the written examination is to be reduced to 85% as per the new rule. Then, my lord, the 15 marks will be added. They take it 50, if it is taken as a 15%, it crosses 100%, more than 100%. To make it 100%, they reduce the written examination marks to 85%. Then it 15 is added, then it will be 100 marks. That is how they make it. If it is taken 15%, it will be 30 marks. It will cost us 100 and it will be 115.
Now the records.
And in the, my lord, entire, the except the Gulbarga, my lord, the other they have followed only interview marks as per the new rule also 15 marks, not the 15% they have taken.
Let us see. Now you place all the records by the next date without fail. How you did the evaluation, written exam, what is the marks, 1:5 for interview when you called. How many people you called in 1:5?
It is.
And then interview marks as per new rule, what you gave, when that was done, you placed that no further adjournment.
Please.
Relist on Wednesday. The respondent number 5. Your respondent number?
Bank, my lord.
Bank is which? 1 and 3.
1 and 3.
1 and 2.
1 and 3 to produce entirety of the records relating to the selection process, including records relating to calling for interview, etc. List the matter on Wednesday. It is made clear that no further adjournment would be given.
Instead of 15, it may be taken up on 22 even also.
On?
22.
Okay, we'll give you a date of choice. Records must be there, no further adjournment.
Please.
List on 22nd. Now you must show in the event, we have not made up our mind, we are going to hear. In the event, we find in his favor, how are you going to, what is the supernumerary post or what legal foundation to protect yourself? You assist the court.
Yes, sir.
In the event, we find that it is impermissible. You have worked for 10 years.
Yes.
So to save yourself in law, what is the way out? Could the court give a direction to create a supernumerary post? Is there a vacant post? Suppose there's a vacant post.
One vacancy is there, Lord. As per my information. Let them clarify, Lord. Along with the report, let them clarify. They can also, the bank can place on record whether there is a vacancy of SDC. I'm told that one person was selected, so did not.
It is no.
Join to the duty.
Recruitment notification which has been called, Your Lordship, in the year 2012. It is not only in respect of the present post. There were around 60, Your Lordship, posts which were called for. In all the 60 posts, Your Lordship, same procedure has been followed. If Your Lordship's each case is accepted,
saying that your lordships 15% marks is incorrect, then your lordships, all those will be affected.
No, no.
Because it is the same procedure which has been adopted.
Correct. See, now what has happened? You are the only one before the court.
Yes, yes.
Isn't it? Huh? So now those are all closed matters. We'll make it clear. If at all we are going to pass an order on merits, that this will not lead to a fresh cause of action with respect to recruitment taking place 10 years.
Yes.
Huh? That will take care of. The third respondent also to state the vacancy in respect of the post in question, which is a matter that may require consideration by court even at an appropriate stage. Now that amendment to the rule that was brought about,
yes,
which according to you enhances the interview marks from 5 to
15%.
15%.
Yes.
Was prospective, retrospective.
That all needs to be, and there is one other, my lord.
Prospective or retrospective?
Yes, that's one issue. My lord, they specifically say in the order that this is to be adopted in the bylaw and it has to be implemented. So far, as on that date, even as of now, also they are not adopted in the bylaw. These are other consequential, my lord, the issues which may come up for the.
Get ready. Yes. You have filed your synopsis?
No, I'll file it.
File it, file it. Respondents to file their synopsis by the next date.
Yes.
Now, no further adjournments, madam.
Sanjay M. Joshi.
On this matter, my lord, state has filed the, my lord, writ appeal, my lord. Writ appeal has to be heard, my lord. Your lordship have it on 21st, my lord. In this matter, my lord, Bernard AZ is appearing because it's a financial, my lord, benefits has to be, my lord, given to the complainant.
At request, relist the matter on
21st, your lordship.
21st.
22nd.
Please, ma'am.
22nd.
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 Please, no problem.
Meanwhile, coffee not furnished, writ appeal copies.
22nd, government advocate to serve copy on counsel for respondent number.
I am contempt. Petitioner, sir, in before earlier.
No, in the
Only
previous-
respondent, sole respondent.
Only one is found.
The counsel for the respondent.
Yes.
Yes.
Sachin M. Mahajan. Hearing for the appellant, your lordship. It is a wife appeal. Husband has filed a decree of divorce before the trial court, your lordship. The decree is.
Ex parte or you have participated?
I have participated, your lordship.
Ah.
Only on the ground that she is living since from 4 years in a Mahagaon. On the only on ground that cruelty also not proved, your lordship. The divorce decree has been granted by the trial court.
Only on the ground?
Only on the ground that she is
Desertion.
desertion.
He's staying up separate.
She is staying separately, but not in a matrimonial house, your lordship. She is staying in a Mahagaon in a husband house, your lordship. He is staying in a Mumbai.
So in the husband's in-laws house, you are staying in your in-laws.
She is staying in an in-laws house, but in-laws was not staying in Mahagaon, your lordship. They are staying in a Mumbai with the respondent, your lordship.
In light of the submission made on behalf of the counsel for the appellant on merits as well, so the stay of the judgment in MC 198 of 2022, and the respondent is specifically restrained from contracting any fresh marriage. If you have to be summoned, emergent notice to the respondent. List after 2 weeks.
KM Khate.
Well, statement of objections draft is ready. I will file weeks time.
At request.
Lord, kindly pass it.
He's going to file something. Let him file. Let us. AGA It's submitted on behalf of the respondent, statement will be filed. Relist the matter week of the next date.
Madam, date,
28.
please.
KM Bhatte.
Lord, kindly pass on my portal.
It is also, my lord, Yashwantrao Chavan University, and it will be taken on same, my lord.
So what is the matter?
My lord, here the certificate, eligibility certificate is, my lord, they have not selected. Some university from Nasik, Open University, they have obtained certificate. On that basis, they are seeking appointment. That is in question, my lord. Yeah, as per NCET, central government, the notification, what is the required qualification is, my lord, it is not there. They are not having that qualification.
We'll hear it.
Please.
Relist the matter on 29.
Please.
This matter ready means if time permits, we'll pass over and.
No, my lord, it is the same hour.
Next.
90.
ನೋಡೋಣ ಯಾರು ಮಾಡಿ
Till number 28. Ashokar Kalyan.
State. Field number 30. Why don't you all get ready?
Accused number 1 to 3 has to proceed, sir. I am for accused number 5, he is for accused number.
Actually 1, 2 and 3, na?
1 and 2, two other advocates are there. And 30.1, I am appearing for accused number 5.
I'm looking for accused number 4.
4, sir.
Santosh Kumar Veeradari.
So we have told him on Monday.
Yes, yes.
We have told him on Monday. So Monday, we'll start that on Monday.
My humble submission is, sir, I will be out of station for cataract operation of my wife for 5-6 days. So it may kindly be taken up on 22. We will finish it up.
ಇವತ್ತೇನಾದ್ರೂ ready ಇದ್ದೀರಾ?
They have to come in, sir, because defense of each accused seems to be different.
Different.
Yes, sir.
So what we can do?
Yes, ma'am.
We'll start on Monday. We'll hear whoever is there.
Yes.
And yours, we will accommodate.
Yes. Oblong.
We'll also have an idea.
Yes.
So then what is in our mind for you to answer, we can mention.
Yes.
So on Monday, we can start.
Yes, ma'am. Yes.
In your Satyanarayana, you are ready.
I'm ready partly because my depends upon the submission of the other accused. I cannot at the same time sell, but so far as the investigation part is concerned, of course it is one to be one and the same. So I'll have to more concentrate on that aspect, and that depends upon what will be the submission by the other side. I mean other accused.
Monday, no.
Monday, yes, I'll be ready.
Because I think that other counsel said he'll be ready on Monday.
Yes, sir.
Sanjay also ready.
If possible, try to file your synopsis.
Yes.
Yes.
Monday will take up. Monday will take up.
Yes.
Yes, I have notes. ಬರ್ಕೊಂಡಿದ್ದ judgment ಏನಿಲ್ಲ.
Yes.
Yesterday, Lords, I have given the village map along with the memo. Lords, I have, Lords.
Adina, what you do?
Yes.
You give one page write-up also.
ಅದನ್ನ ಮಾಡಿಸ್ತಾ ಇದ್ದೀನಿ. Today I will do it, Lords, exhibit wise, Lords, I will submit a synopsis.
So now you tell us.
Yes.
What are the exhibits?
Yes.
How you are going to equate exemplar?
Yes.
So according to you.
Yes.
The trial court has merely referred to an award of a different village.
Yes, different village notes.
Different village.
Yes.
And has not given, has ignored your evidence.
Yes.
Huh?
Yes.
Though the trial court has mentioned that you should have produced award of the police station.
Yes, yes.
Etc. But
Yes.
you are saying even otherwise, it would prima facie show that the land is developed.
Developed.
Huh?
Developed. Even as per the Lord's SLAO's award, it is just Lord's abutting national highway acquired for a purpose for establishment of a vehicle terminus. Opposite to the acquired land is a bus stand, and Lord's it is surrounded by government offices. Not only this Lord's private residential layout.
As on the date of the preliminary notice.
Yes, Lords.
Okay, now you take us. You continue. You continue your.
Lords,
Yes, now take us through the exhibits now.
Lords, yes.
Please here.
ಇದನ್ನ ಮೆಮೊ ಹಚ್ಚಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿನ್ನೆ. Lords, may I once again for convenience of my lordship, refer to exhibit R1, Lords.
Exhibit
R1. Is the award passed by the land SLAO.
Page number 3, correct.
At page number 3.
Once the claimant leads evidence.
Yes.
The other side don't lead, is it?
In most of the
No,
cases.
what is the procedure we want?
Procedure is in most of the cases, the authorities, they don't lead evidence.
But in law, what?
Typically, my lords, it is the burden is upon the claimant to, my lords, prove the my lords, market value of the land. If there are, my lords, suppose, my lords, if I rely upon documents and which are, my lords, of higher value, and there are sales statistics of, my lords, surrounding the acquired year. Lords, if they are within the knowledge of the authorities, they can very well, Lords, lead their evidence, produce them before the court, and can say that, Lords, those sales statistics which are relied upon by the claimants, Lords, cannot be.
On this point, one authority I want. Just do your research on the next date.
Yes, Lords. Yes.
That if the authority.
Yes.
Do not lead, or are they required or not?
Yes.
Examine that.
And Lords, one submission is accept bare denial. Lords, if evidence is perused, cross-examination of the claimant, they don't say that, Lords, as on the date of acquisition, all these, Lords, build.
Yes, see, that
Yes, yes, yes.
Now, award is exhibit R.
R3, Lords. R1, sorry. R1 ಅಲ್ಲಿ page number 3, paragraph 9. May I read?
Yes.
ನಾನು ದಿನಾಂಕ 12/11/2002 ಇಂಡಿ ತಾಲೂಕು ಪೈಕಿ ಜಳಕಿ ಗ್ರಾಮದ ಜಮೀನುಗಳನ್ನು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 13 ಕಿಲೋಮೀಟರ್ 48.80 ಪಕ್ಕದಲ್ಲಿ ವಾಹನಗಳ ತಂಗುದಾನದ ಬಗ್ಗೆ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡ ಜಮೀನುಗಳ ಐತೀರ್ಪು ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಸದರಿ ಜಳಕಿ ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 12 ದಟ್ ಈಸ್ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ ನೇದರ ಸ್ಥಳ ಪರಿಶೀಲನೆಯನ್ನು ಜಮೀನ್ ಮಾಲೀಕರ ಒಟ್ಟು ಮುಕ್ತಿಯಾರರಾದ ಶ್ರೀ ಗಿರೀಶ್ ಝಳಕಿ, ಭೂ ಸ್ವಾಧೀನ ಸಂಸ್ಥೆಯ ಪ್ರತಿನಿಧಿಯವರಾದ ಶ್ರೀ BP ಕಿಚಡಿ, ಪ್ರಥಮ ದರ್ಜೆ ಭೂಮಾಪಕರು ಹಾಗೂ ನಮ್ಮ ಕಾರ್ಯಾಲಯದ ಭೂಮಾಪಕರುಗಳೊಂದಿಗೆ ಮಾಡಿದ್ದು ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನು ಸಮತಟ್ಟವಾದ ಭೂಮಿ, ಕರಿ ಮಿಶ್ರಿತ ಕೆಂಪು ಮರಡಿ ಮಣ್ಣು, ಯಾವ ಕಟ್ಟಡಗಳು ಇಲ್ಲ, ಗಿಡಗಳಿಲ್ಲ, ಖುಲ್ಲಾ ಪಡಾ ಜಮೀನು ಇದೆ. ಬಸ್ ಸ್ಟ್ಯಾಂಡಿಗೆ ಸಮೀಪವಿದೆ. ಜಳಕಿ ಗ್ರಾಮದಿಂದ 1 ಕಿಲೋಮೀಟರ್ದಲ್ಲಿದೆ. 300 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ KEB ಗ್ರಿಡ್ ಇದೆ.
Yes.
Beyond this KEB grid is the KEB quarters. Survey number 11.
This is the admitted position.
Yes. As on the date of
KEB grid ಇದೆ ಅಂತಾರೆ. It is a receiving station.
ಅದ್ರ
ಹೈ ಟೆನ್ಷನ್ ವೈರ್ಸ್ ಅದೆಲ್ಲ ಇರ್ತದೆ. ಕ್ವಾರ್ಟರ್ಸ್ ಇದೆ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ exhibits. I have produced the exhibits.
So bus stand is admitted.
ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ is ನಿಯರ್ ಇದೆ ಅಂತ ಹೇಳಿದಾರೆ. ಬೈ ದ ಸೈಡ್ ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಇಲ್ಲ. ಸಮೀಪವಿದೆ.
Yes.
I have also produced photographs. It is this acquired land is on the left side, bus stand is on the right side, diagonally opposite. If not directly opposite, it is diagonally opposite to the acquired land.
So now you take us through your what all the documents you are.
Yes, Lords. Exhibit P5, Lords.
Yes.
This is the Lord's survey number in respect of survey number 227.
227.
This is KEB office and quarters, Lords. KEB office and quarters.
What is this? This is the form number 9.
Grama Jalki, form number 9.
KEB office.
KEB office ಹಾಗೂ quarters. ಕೊಟ್ಟಿದ್ದೀನಿ ಅದನ್ನ. It is along with the memo yesterday.
So now this is property number
227.
227.
Yes.
Office ಹಾಗೂ quarters.
Yes. ಆಸ್ತಿಯ ವಿವರ KEB.
Quarters.
Yes.
Exhibit P.
This is exhibit P5.
Now this.
And this date of document may kindly be seen. This is of the year 2003-2004.
ಎಲ್ಲಿದೆ?
ಮ್ಯಾಲ್ ಟಾಪಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ 2003-2004 ಟಾಪ್ ಆಫ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
2003-2004. Preliminary notification.
Preliminary notification is dated 10/11/2000. 10/11/2000. It was existing even prior to preliminary notice.
41 is of 23/2/2001.
ಇಲ್ಲ ಸರ್, ತಪ್ಪು ಆಗೈತಿ. 10/11/2000 is the correct.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲ ತಪ್ಪಿದೆ. 10/11/2000 is the correct date of 41.
10/11/2000. So this KEB quarters.
Yes, and office.
Exhibit P6 is in respect of survey number 10, my lords. That is adjacent to acquired land. ಜಿಲ್ಲಾ ಪೊಲೀಸ್ ವರಿಷ್ಠಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ.
This is RTC.
RTC. And lots of police quarters and office have also come up. Photographs to that effects are produced.
P5 and P5 and 9
P5,
and 9.
9.
No, but how are you? Only thing is, now as on that date, how you are going to show? Now, no doubt it's there as of.
Yes. Even lots exhibit P5 if lots may peruse. It is 2003 and 4. 5. That KB quarters and office, it is 2002 and 3. And it has not come up in the 2003 or 4 itself. It was existing even prior to that.
Stated in your evidence.
Yes.
You have stated in your evidence.
ಇತ್ತು ಅದನ್ನೇ ನಾವು ಎಲ್ಲ ಹೇಳಿದೀವಿ. And bus stand, even as per the Milord's SLAO award, he says bus stand is there, KB grid office is there.
You have stated in your chief.
Yes, yes.
Of the existing.
Yes, yes, yes.
They have not cross-examined on this.
Cross-examined in the sense Milord's nothing Milord's.
Let us see, afterwards you take us.
Yes, yes.
Next.
Exhibit P7 is Milord's the bus stand, survey number 228.
This is also Form 9.
Yes, Milord. 2003-4.
This is P.
P7.
Yes.
Then Milord's exhibit P8.
Yes.
It is Astiya Vivara Kattada. PWD Bungalow.
Yes.
Exhibit P9, Milords. That is in respect of survey number 5, Sarkari Inspection Bungalow, IB, Milords. Government IB.
In your sketch, where do you show?
Yes, I'll just exhibit P9.
Yes, yes.
That is at the intersection of the highway, Milords. Crossroad towards north.
P9.
Yes.
RTC. Yes.
Exhibit P10 is survey number 8, which is converted to non-agricultural purpose. Photographs are produced and
P10.
P10, that is in respect of survey number 8.
But when that was converted?
Alienated and bandide, but
it looks subsequent to them.
around 2003 and 4 notes, MR number 2000.
Subsequent to preliminary notice.
Yes, yes.
Next.
Notes P11.
Exhibit P11 is the sale deed. It is sale deed in respect of a portion of agricultural land only. Though maybe in size it is small.
What is the date of the sale deed?
Sale deed is dated 19/2/2001.
No, notification is 2000.
No, 4-1 notification is 2000, 10/11/2000. And Milord's
4-1 notification date?
10/11/2000.
10/11.
2000.
Now, what is the extent of subject matter of the sale deed?
Milords, under this sale deed, an extent of 2 guntas of land, agricultural land, was sold for 20,000. That is 10,000 each per gunta.
Now you'll have to tell us the legal position of small plot,
Yes, that I will, Milords.
because this is a small plot admittedly.
It is not a plot, Milords. Yeah, it is a agricultural land only. It is not converted to any purpose. Earlier, Milords, ಮೊದಲು 1 ಗುಂಟೆ 2 ಗುಂಟೆ 5 ಗುಂಟೆ ಮಾಡಕ್ ಮಾರಾಟ ಮಾಡಕ್ ಅವಕಾಶ ಇತ್ತು.
So,
Sold on
this is 2 guntas of agriculture land.
Yes.
Huh?
Yes, ma'am.
Huh.
ಪೂರ್ವ ದಿಕ್ಕಿನ ಮಧ್ಯದಲ್ಲಿ ರಸ್ತಾ ಬಿಟ್ಟು ಕ್ಷೇತ್ರ 2 ಗುಂಟೆ.
Huh.
ಆಕಾರ ಜಿರಾಯತ್ ಮರಡಿ ಜಮೀನು. ಇದಕ್ಕೆ ಚೆಕ್ ಬಂದಿ ಬ್ಲಾಕ್ 10 ರಸ್ತಾ ಸಲುವಾಗಿ ಸರ್ಕಾರಿ ಶಾಲೆ ಪೂರ್ವಕ್ಕೆ ಸದರಿ ಬ್ಲಾಕ್ ಉಳಿದ ಜಮೀನು.
So how we are going to take a small bit, which is this 10 acres? You have
Yes,
to give
that
us
I
some
will, Milords,
authority.
yes, with authority I will submit. And Milords, so far as these 3 sale deeds are concerned, if Milords may peruse this exhibit P11 is a sale deed in respect of block number 42.
Plot number?
42.
Huh.
This block number 42, it is situated in anterior road,
Huh.
not on the national highway.
The Pandarapur road is, what is that road?
This is, Milords, again now this road has been converted to, upgraded to a national highway. This road leads to Indi to Pandharpur road.
Yes.
Block number 42, Milords, got it in the map.
Yes, yes.
Yes, this is not abutting to national highway. It is only a state highway, maybe district main road at that particular point of time.
Yes.
Then, Milords, exhibit P12.
Yes.
Is sale deed dated 19/7/99. This is prior to 4-1 notification.
P12.
Yes,
What is the extent?
3 guntas of land.
Where does it come in your map?
Exhibit P12 notes, that is at the intersection
Yes, yes,
beyond IB notes, government IB.
yes.
It is all, it also not
Now, this map is an extract of the village map.
marked as exhibit P8.
Yes.
And this exhibit, Milords, P12, block number 3, has also no, Milords, frontage to the either main road or the national highway. It is situated anterior.
Yes. Yes.
Then let's exhibit P13.
What was the cost? P12?
Exhibit P12 notes 3 guntas of land was sold for rupees 26,500.
Yes.
And exhibit
Roughly 8,000
odd.
Huh?
Almost 9,000. 8,900. And
yes.
And exhibit P13 notes. This is also sale deed in respect of survey number 344. This is subsequent to 41 and 61 notification. This sale deed is dated 11/4/2007.
That will ignore. Your other evidence is better. This will ignore. P13
Alla.
will ignore.
P13 ಕೆಲವೊಂದು judgment ಅಲ್ಲಿ de-escalation
If there are no, any available is not available.
5 years ಮೇಲೆ 5 years ಮೇಲೆ 5 years ಮೇಲೆ doubtful, isn't it? De-escalation also.
Even otherwise, lords, I have restricted my claim to rupees 4 lakh.
What other evidence?
Then, lords, exhibit P14 LS judgment of lords in LAC 816 and 817. They may not be lords useful for because it is in respect. Yes. Exhibit P15 is award, again award, and 1860. These documents may not be relevant for the fixing the market value of the land. So, lords, on these documents, lords.
Now the national highway.
Yes.
It is written as national highway na ಏನು map ಅಲ್ಲಿ?
National highway.
ಅಂತ ತೋರಿಸಿದ್ಯಾ ಅಲ್ಲಿ map ಅಲ್ಲಿ?
ಹೌದು.
ಹಾ?
SLA ಅವಾರ್ಡ್ ಅಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ. ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 313 ಅಂತ ಹೇಳಿ.
ಅಂತಿದೆ.
ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ.
Just point out.
Yes. Award exhibit R1 page number 3 minutes. Paragraph 9. ನಾನು ದಿನಾಂಕ 12 ಜಳಕಿ ಗ್ರಾಮದ ಜಮೀನುಗಳನ್ನು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 13ರ ಕಿಲೋಮೀಟರ್ 48.80 ರ ಪಕ್ಕದಲ್ಲಿ ವಾಹನ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು
NHAI 13.
Yes, National Highway.
So there's a frontage.
Frontage.
How much frontage?
Frontage, exact what was the frontage?
It hasn't come out.
It has not come. It may be more because of the reason the purpose for which it is acquired is a parking of vehicle terminus.
Yes. So this is the admitted position.
Yes, admitted position. It is not in this.
Now in the cross examination.
Yes. In fact, this appellants, they had made an application even before issuance of notification for conversion of their land from agricultural to non-agricultural purpose. That document is also marked in evidence, but for some reasons, lords, it was not carried forward and it was left at that stage itself.
Which year?
Lords, 1998. I shall note, sir. 1995. Exhibit P30, my lords.
Even as per my instructions, my lord, even today also remaining 5 acres, they have not converted.
Exhibit P13,
My lords, P30, my lords.
30.
Yes.
Can you find out by the next date if Survey of India map is available?
Survey of
India map is available.
India.
India,
India map.
India map.
Survey of India ಅಂತ ಒಂದು map ಇಟ್ಟಿದೆ.
Yes.
Find out if it is there available.
Map.
Any public record,
Google map.
huh?
Google.
But then we can't date it back to that time, isn't it? Google map, we can't date it
Yes,
back.
yes, yes.
If there's any other public record, you just have a look at it. P30, isn't it?
Yes, my lords. March 1995.
ಅಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಕೋರಮಂಗಲ ಅಲ್ಲಿ ಒಂದು ಸರ್ವೆ ಆಫ್ ಇಂಡಿಯಾ ಆಫೀಸ್ ಇದೆ. They maintain these maps, having all entries.
Yes, Nagpur ಅಲ್ಲಿ ಇದೆ head office.
Nagpur.
Yes, ma'am.
Anyhow,
ಎಲ್ಲ all district, major district road center ಎಲ್ಲಾನು ಅದರಲ್ಲಿ ಬರುತ್ತೆ.
ನೋಡೋಣ. Just read the application relevant provision portion.
Exhibit P30, my lords. ಬಿನ್ ಶೇತಿಗಿ ಸಲುವಾಗಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡುವ ಕುರಿತು ಮೇಲ್ ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ಬ್ಲಾಕ್ ನಂಬರ್ 12 ಖಾತೆ ನಂಬರ್ 203 ಅಲ್ಲಿ ನಾನು
Which is this block number 12?
ಬ್ಲಾಕ್ ನಂಬರ್ 12 ಖಾತಾ ನಂಬರ್ ಬೇರೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಸ್ವಾಮಿ. This acquired land is block number 12.
Block number 12. Block and survey number is same.
ಖಾತಾ ನಂಬರ್ ಬೇರೆ ಕೊಟ್ಟರು.
ಇರ್ಲಿ. Block number.
survey number
same.
Yes. 2 ಎಕರೆ landlords he had sought for conversion.
This is dated?
This is dated 10th March 1995.
10th March.
Yes.
Where do you get the date?
At the bottom towards left notes. Jalki 10 March 1995.
95. So this would indicate that it has that potential.
Yes.
Yes. Now what is the evidence cross-examination?
Yes. And what's with
P17 ಏನು?
Exhibit P17 what's blueprint map of survey number 12, that is the acquired land.
It's a private map. Now this, in the village map, these things are not shown as such.
No, they only show what survey number ಏನಿದೆ ಅಂತ ಹೇಳಿ.
Road is shown.
Yes. ಈಗ even though Milords Gram Panchayat office of Jalki, Milords is a part of Milords block number 12 acquired land. It has been marked in that map, but it does not indicate that it is a Milords village Panchayat office, Gram Panchayat office.
So what is the evidence now?
Yes.
Oral evidence, what is the cross-examination? Now you also get instructions from it. Ask their officials. If it's a fact that though some of the documents are dated later, you can verify whether yes, office is there, police quarters was there. Orally, as on the date of 4/1, you find out by the next day. We will accept what you say. Yes. ಇದೆ ಅಂದ್ರೆ ಇದೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
ಹೌದು.
Yes.
May I read? cross-examination of
Yes, cross-examination of
PW1. He is the sole witness, my lords.
You will also have to answer the question, government. What is the effect of not leading evidence? Is it required, not required in reference proceedings? You please find out.
And at this stage, my lords, with respect to Exhibit P 11, 12 and 13, those sale deeds, my submission is that, my lords, those sale deeds which are situated anterior in the village, my lords, anterior part of the village, which had no frontage, which are not, my lords, ideally located, my lords, the price as compared to the acquired land would be lesser to those lands. This acquired land which is abutting national highway, having more frontage, my lords, and surrounded by, my lords, properties would always fetch higher price than those land. If, my lords, if in those sale deeds it is mentioned as, my lord, 10,000 per gunta, my lords, obviously, my lords, the price of the land acquired would be on the higher side.
We'll take note on that small plot, one authority.
I shall furnish.
Now take us to the evidence.
Yes. I will start from the beginning of the cross examination.
Yes.
So it for.
Yes.
ನಾನು 2003 ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದೆ. ಆ ಜಮೀನು ಒಣ ಬೇಸಾಯ ಜಮೀನು ಇರುತ್ತದೆ. 2000 ಸಾಲಿನಲ್ಲಿ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ನಲ್ಲಿ ನಮ್ಮ ಊರಿನ ಹೊಲಗಳ ದರ ನಿಗದಿ ಎಷ್ಟು ಆಗಿತ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ. 2000 ಸಾಲಿನಲ್ಲಿ ನಮ್ಮ ಜಮೀನು ಆಜು ಬಾಜು ಹೊಲಗಳು ಖರೀದಿ ಕಿಮ್ಮತ್ತು ಎಷ್ಟು ಇತ್ತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. 2000 ಸಾಲಿನಲ್ಲಿ ನಮ್ಮ ಆಜು ಬಾಜು ಹೊಲ ಮಾರಾಟ ಆದ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. 2000ಕ್ಕಿಂತ ಮೊದಲು ನಾನು ಹೊಲದಲ್ಲಿ ಏನು ಬೆಳೆಯುತ್ತಿದ್ದೆ.
ಬಾಕ್ಸ್ ಹೋಗಿಂತ ಮುಂಚೆ ಸ್ವಲ್ಪ ಹೇಳಿಕೊಡ್ಬೇಕು.
ಇಲ್ಲ ಇತ್ತಂದ್ರೆ if milords there were any sale deeds, whatever was available that has been milords marked in evidence. ಅದೇ ರೀತಿ ನನ್ನ ಹೊಲದಲ್ಲಿ ಏನು ಬೆಳೆಯುತ್ತಿದ್ದೆ APMC ರವರು ಕೊಡುವಂತ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಅದೇ ರೀತಿ ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ 2000ನೇ ಇಸ್ವಿ ಏನೇನು ಬೆಳೆ ಬೆಳೆದಿದ್ದಾರೆ ಅನ್ನುವ ಬಗ್ಗೆ APMC ರವರು ಕೊಡುವಂತ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಲಕ್ಷ್ಮೀಕಾಂತ್ ಬಿರಾದರ್ ಅನ್ನುವರ ಬಗ್ಗೆ ಖರೀದಿ ಕಾಗದ್ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಸದರಿ ಎಕ್ಸಿಬಿಟ್ P13 ನೋಟ್ಸ್.
P13.
ಸದರಿ ಖರೀದಿ 2007ರಲ್ಲಿ ಆಗಿದ್ದು, ನನ್ನ ಜಮೀನು 2000ರಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನ ಪಡೆದುಕೊಂಡಿದ್ದು, ಸದರಿ ಮಾರಾಟ ದರ ನನ್ನ ಕೇಸಿಗೆ ಅನುಕೂಲ ಆಗುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಅಶೋಕ್ ಹುಗಾರ್ ಇವರಿಗೆ ಬೀರಪ್ಪ ಪೂಜಾರಿ ಅವರು ಮಾರಾಟ ಮಾಡಿದ ಖರೀದಿ ಕಾಗದ ಹಾಜರುಪಡಿಸಿದ್ದು, ಅದು ಕೂಡ 2000 ನಂತರ ಆಗಿದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P14 ಜಳಕಿ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಇವೆ ಅಂದರೆ ಸರಿ. ನಿಶಾನೆ P14 ಬಿಜಾಪುರ್ ರಿಂಗ್ ರೋಡ್ ಸಂಬಂಧಪಟ್ಟಿದೆ ಅಂದರೆ ಸರಿ. That is milords in respect of awards, which I said milords, it may not be relevant. ಸರಿ. ಸದ್ರಿ ರಿಂಗ್ ರೋಡ್ ಬಿಜಾಪುರ ಪಟ್ಟಣ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದರಿಂದ ಮತ್ತು ಜಳಕಿ ಸಣ್ಣ ಗ್ರಾಮ ಇರುವುದರಿಂದ ಎರಡಲ್ಲಿ ಮಾಡಿದ ದರದ ನಿರ್ಧಾರ ಒಂದೇ ಇರುವುದಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ. ಬಿನ್ ಶೇತ್ಗಿ ಸಲುವಾಗಿ ನಿಶಾನೆ P30 ಮತ್ತು 31 ಅನ್ನು ನಾನು ಕೊಟ್ಟಿದ್ದು ಅಧಿಕಾರಿಗಳು ಬಿನ್ ಶೇತ್ಗಿಗೆ ಯೋಗ್ಯ ಇಲ್ಲ ಅಂತ ಅರ್ಜಿ ಪರಿಗಣಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಹಣಕಾಸಿನ ತೊಂದರೆಯಿಂದಾಗಿ ಅರ್ಜಿ ಕೊಟ್ಟ ನಂತರ ನಾನು ಮತ್ತೆ ವಿಚಾರಿಸಲು ಹೋಗಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ KEB ಸ್ಟೇಷನ್ ಇತ್ತೀಚೆಗೆ ಆಗಿದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಅದನ್ನು this suggestion itself is incorrect because SLA himself says that there was a KEB station. ಸರಿಯಲ್ಲ. ಅದನ್ನು ಭೂ ಸ್ವಾಧೀನ ಮಾಡಿಕೊಳ್ಳುವಾಗ ಕೂಡ ಕಡಿಮೆ ದರ ನಿಗದಿ ಮಾಡಲಾಗಿತ್ತು. KEBಗೆ ಸ್ವಾಧೀನ ಮಾಡಿಕೊಂಡ ಆಸ್ತಿ ನಮ್ಮದೇ ಇದೆ. ಸದರಿ ಭೂ ಸ್ವಾಧೀನ ಆದೇಶದ ಮೇಲೆ ನಾನು ಅಪೀಲ್ ಹೋಗಿಲ್ಲ. ನಮ್ಮ ಜಮೀನಿನ ಸುತ್ತು ಸರ್ಕಾರಿ ನಿವೇಶನಗಳಾಗಿ ಭೂ ಸ್ವಾಧೀನ ಮಾಡಿಕೊಂಡಿದ್ದು ಅವುಗಳಿಗೆ ಎಷ್ಟು ಪರಿಹಾರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ. ಈ ಸಜೆಷನ್ ಇಸ್ ಮೇಡ್ ದಟ್ ದೇರ್ ಆರ್ ಸರ್ಕಾರಿ. ನಮ್ಮ ಹೊಲದ ಎದುರು ಬಿನ್ ಶೇತ್ಕಿ ಪ್ಲಾಟ್ ಆಗಿದ್ದು ವೈಭವ್ ನಗರ್ ಇರುತ್ತದೆ. ವೈಭವ್ ನಗರ್ ಆಸ್ತಿ 2007ರಲ್ಲಿ ಬಿನ್ ಶೇತ್ಕಿ ಆಗಿದ್ದು ಇದೆ.
Vaibhav Nagar is the opposite.
Opposite. my lord's photograph is produced. ಆಗಿದೆ. ನಮ್ಮ ಆಸ್ತಿ ಹತ್ತಿರವೇ ಪೊಲೀಸ್ ಠಾಣೆ, ಹೋಟೆಲು ಇವೆ ಅಂತ ಸುಳ್ಳು ಬರೆಸಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಜಮೀನು, ಹೋಟೆಲು ಮತ್ತು ವಸತಿ ಗೃಹ ಕಟ್ಟಲು ಯೋಗ್ಯ ಜಮೀನು ಇದೆ ಅಂತ ಸುಳ್ಳು ಬರೆಸಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. RTO ರವರ ವಾಹನ ನಿಲ್ಲಿಸಲು ನನ್ನ ಹೊಲ ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ ಅಂದರೆ ಸರಿ. ಅದೇ ರೀತಿ ಕಡಿಮೆ ಬೆಲೆಗೆ ತೆಗೆದುಕೊಂಡಿದ್ದಾರೆ. ಜನರಿಗೆ ತೊಂದರೆ ಆಗಬಾರದು ಅಂತ ಊರಿನ ದೂರ ಇರುವ ಜಮೀನು ಸ್ವಾಧೀನ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬಿಜಾಪುರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನದ ಬಗ್ಗೆ ಪರಿಹಾರಧನ ನಿಗದಿಪಡಿಸಿದ ಬಗ್ಗೆ ಬರೆದು ನನ್ನ ಜಮೀನು ಗ್ರಾಮದಲ್ಲಿ ಇದ್ದುದರಿಂದ ಈ ಕೇಸಿಗೆ ಅನುಕೂಲವಾಗುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆದಂತ ಆದೇಶ ಪ್ರತಿ ಹಾಜರುಪಡಿಸಿದ್ದು ನನ್ನ ಕೇಸಿಗೆ ಅನುಕೂಲ ಆಗುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. 2000 ಸಾಲಿನಲ್ಲಿ ಜಳಕಿ ಗ್ರಾಮ ಅಷ್ಟೊಂದು ಅಭಿವೃದ್ಧಿ ಹೊಂದಿರಲಿಲ್ಲ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. 2010ನೇ ಸಾಲ ಜಳಕಿ ಗ್ರಾಮದ ಸದ್ಯದ ಪರಿಸ್ಥಿತಿ ಆಧಾರದ ಮೇಲೆ ನಾನು ಪರಿಹಾರ ಧನ ಕೇಳುತ್ತಿದ್ದು ಸರಿಯಲ್ಲ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಬೆಲೆಗೆ ಮಾರಾಟವಾಗಿದ್ದ ಮಾರಾಟವಾಗಿದ್ದು ಅದರ ದೃಢೀಕೃತ ಖರೀದಿ ಪತ್ರದ ನಕಲನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಇರುತ್ತದೆ. ಈ ಜಮೀನು ಸಹಿತ ನನ್ನ ಜಮೀನಿಗೆ ಹೊಂದಂತೆ, ಜಮೀನು ಪೂರ್ವಕ್ಕೆ ಒಳ ರಸ್ತೆಗೆ ಹೊಂದಕೊಂಡಂತೆ ಇತರೆ ನಮ್ಮ ಜಮೀನು ಮುಖ್ಯ ರಾಷ್ಟ್ರೀಯ ಐ ಥಿಂಕ್ ದೇರ್ ಇಸ್ ಸಮ್ ಮಿಸ್ಟೇಕ್. ಇಷ್ಟೇ ಕಂಟಿನ್ಯೂಯೇಷನ್. ಗಾಟ್ ಇಟ್. 2000 ಸಾಲಿನಲ್ಲಿ ನಾನು ಜಮೀನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದು ಅದನ್ನು ಶೇತ್ಕಿ ಜಮೀನು ಅಂತ ಪರಿಗಣಿಸಿ ಪರಿಹಾರ ಕೊಟ್ಟಿದ್ದಾರೆಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಬಿನ್ ಶೇತ್ಕಿಯ ಚದುರ ಅಡಿ ಬೆಲೆಯನ್ನು ಕೇಳುತ್ತಿದ್ದೇನೆ, ಅದು ನನ್ನ ಕೇಸಿಗೆ ಅನ್ವಯವಾಗುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. 2000ರಲ್ಲಿ ನನ್ನ ಜಮೀನು ಬಿನ್ ಶೇತ್ಕಿ ಆಗಿರಲಿಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ರೆಫರೆನ್ಸ್ ಅರ್ಜಿಯನ್ನು ಕಾಲ್ಮಿತಿಯಲ್ಲಿ ದಿಸ್ ಇಸ್ ದ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್.
Let us see. Now you take next date when you want. When you
16th.
Huh?
16th.
By then, if you get any public document.
Even I can try to.
There is some doubt now. Some of the document 2003-4 may be there, but for.
Even prior to that, if there are any document.
No, same buildings, what you are saying.
Yes, same building.
Whether it's existing.
Prior to that.
If you can get any RTI response or something, you see.
Yes, I can get it.
Because no doubt it may be there, but you have to also show, isn't it?
Yes, I shall do that.
Now, so far as bus stand, not in dispute. National highway, not in dispute.
KEB.
How to see, we'll see. Now, the PWD, etc., what you are saying.
KEB is also not dispute.
KEB. ಅದು 3-4 ಅಂತ ಏನೋ ಇದ್ದಂಗಿದೆ ನಿಮ್ ರೆಕಾರ್ಡ್ಸ್. So whether it was there on 2000.
I shall not verify, and if they are available minutes, I will get it. 16th minutes ಸ್ವಲ್ಪ ಅಂದ್ರೆ ಎಲ್ಲ ರಜಾ ಅದಾವ, ಅದಕ್ಕೆ ಸಿಗೋದು ಕಷ್ಟ. ಇನ್ನೊಂದು 4 ದಿನ ಜಾಸ್ತಿ ಕೊಟ್ರೆ I can.
Just will go through the LCR melody. Yesterday ನಿನ್ನೆ ಮಧ್ಯಾಹ್ನ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇತ್ತು ಅಂತ ನೋಡ್ಲಿಲ್ಲ. We will go through the LCR and AG Archana madam has gone through the file.
We'll have it on that next Monday we'll have it.
Yes. 20th.
Yes. But you have to give some document which are public documents which they will not be in a position.
Existence of those properties prior to 4-1 notification.
Whatever you have given, same exhibits.
Same exhibits.
Police station, etc.
Yes.
If there is something which is a public document, some city survey sketch, whatever it is.
Yes.
Then let us see. You also verify.
In most of the cases, what happens is, Lords, when we, at the time of entering into witness box, we start collecting evidence. ಅವಾಗ ಆ ತಾರೀಕು ಆ ವರ್ಷದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ, ಅದನ್ನೇ ತಂದು ನಾವು ಕೋರ್ಟಿಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ. Now we will, that is the reason why.
Correct, but now if there's any chance of
getting those documents,
that, just have a look.
Please.
Some RTI response.
Please.
Yes. Individually to the authorities.
Please.
And if they give, we will see.
Yes.
You verify government.
Please.
ಅಲ್ಲ ಇದೆ ಅಂದ್ರೆ ಇದೆ.
ಆಯ್ತು. ಯಾವಾಗ ಕಟ್ಟಿದ್ದಾರೆ ಅದು ಟೆಂಡರ್ ಆಗಿ ಮಾಡಿ ಕಟ್ಟಿದ ರೆಕಾರ್ಡ್ ಏನಿದೆ
ಫೈಂಡ್ ಔಟ್.
It will be helpful. They can get quick response from the authorities more than us.
ಆಯ್ತು, ಅವ್ರ ಮೇಲೆ ತುಂಬಾ ಡಿಪೆಂಡ್ ಆಗ್ಬಿಟ್ಟು.
ಇಲ್ಲ, ನನ್ನ ಕೆಲಸ ನಾನು ಮಾಡ್ತೀನಿ.
PWD bungalow, usually that will be thing.
Yes.
To get some RTI response there.
Yes, yes, my lords, I will get it, my lord. I will get it.
Definitely in those bungalows, VIP.
No, VIP. It is most, my lords, notorious place, my lords, known throughout the state, this particular, for all good and bad reasons.
That government also cannot dispute.
That area.
Only
Sir,
IBL
Indi Jalki check post, Jalki check post.
Border, Maharashtra, Karnataka border ಬರುತ್ತೆ ಸ್ವಾಮಿ.
Anything in the public domain you.
Yes, yes.
Yes.
I appear for the respondent, serial number 29.
20.
29 minutes.
Just, there is some criminal appeal we want to take. We'll repeat it. Repeat it. Huh? We want to take some criminal appeal today.
Any date may be given.
Idangi continue ಮಾಡಿ.
2015
We'll
matter.
continue this.
Please
continue in the list.
Please, 2015 matter.
Correct.
Appointment
That's
of
why
land
continue
loser.
it in the list.
Please.
It will be repeated.
Monday, Tuesday.
We'll repeat it.
Oblige.
Let it be in the list.
Please, man.
Land loser appointment.
Huh?
Land loser, appointment of land loser. We filed contempt, they filed the appeal, pending it bit to contempt for court.
We'll consider it.
This is how.
We'll consider it.
Please.
Yes.
24. Arrest legally.
Okay.
This present appeal would emanate from a judgment and order of conviction, not dated 10/9/2023 in Sessions Case 90 of 2017, Lords, passed by the Honorable 4th Additional District and Session Judge, convicting the appellant on 4 counts, that is on the count of murder, that is under Section 302, attempt to murder 307, and criminal intimidation and threatening, Lords, under 506. And all these counts, and the principal punishment would be under Section 302, life imprisonment and a fine of ₹1 lakh. And Your Honor, so far as Section 307 is concerned, Lords, rigorous imprisonment for 5 years and a fine of 20,000. And so far as Section 504 is concerned, Lords, simple imprisonment for 6 months and fine of ₹2,000. And Section 506, the last count, Lords, simple imprisonment for 6 months and fine of ₹2,000. The appellant, Lords, had been arraigned as a sole accused before the trial court, and he stood trial for the offences, all these 4 counts, Lords, 302, 307, 504, and 506. Lords, the substance of accusation leveled against the appellant is that, Lords, deceased Rehana, Lord, she happens to be his wife, and their marriage was solemnized about 10 years prior to the incident, and they had 3 children born to them. it appears that, my lords, that there was a dispute between this appellant and said Rihanna, as the appellant appears to be a person who used to suspect his wife. Further, my lords, said Rihanna, being fed up with his behavior, she would have, along with the children, she would have started residing at her parental place at Indy. And meanwhile, Your Honor, in order to eke out her livelihood, about 2 years prior to the incident, she would be working as a cook in madrasa, situated on Airsang Road, near the railway station of Indy, my lords.
Staying separately, together.
No, they've been separately. He is resident of Sindhi village, Sindhi Taluk, my lords, Kadni village of Sindhi Taluk, whereas she, my lords, now after the separation, was residing with her parents at Indy, and she was working in a madrasa as a cook. She was preparing or maybe working as a helper to the cook at a madrasa situated in Indy near the railway station on Ahirsang Road, my lords. And my lords, there were repeatedly the appellate would visit her at the madrasa and used to pick up quarrel, suspecting her fidelity, stating that she had illicit affair with the preachers or the maulanas at the madrasa, my lords. And such being the state of affairs, my lords, on 24/9/2015 at about 8 p.m., when the deceased was at the workplace, that is at madrasa cooking, my lords, at that time, this petitioner, this appellant, my lords, armed with an axe, would come to the place of work and assault her, give her a fatal blow, would give her a fatal blow on the head. Immediately, my lords, complainant, who is PW2, who is Hussein B, she tries to intervene and try to rescue the deceased. At that time, my lords, the appellant would even assault her. And then, my lords, when the people start gathering, he would flee the place. And while fleeing the place, he would threaten them, stating that today maybe you are spared, but in future I would not spare. He would leave, my lords. With the axe, he would leave. And ultimately, my lords, the complainant and the deceased were shifted to Spandana Hospital at Indy. The wife, that is Rehana, the wife of the appellate, for higher treatment was shifted to Government Hospital, District Hospital, Vijaypura, where, my lords, she would succumb to injuries on the next day, my lords. That is on 25/9/2015, she succumbed to injuries. And this complainant, Hussein B, my lords, she was at Spandana Hospital, where she would lodge a complaint as per Exhibit P3, my lords. These are the facts, my lords. And during the course of investigation, the appellant came to be arrested on 22/11/2015, my lords. And since then, he's in custody, my lords. All throughout during trial, he was in custody. So now, my lords, in order to establish these charges, the prosecution in all has examined 19 witnesses, my lords. I have supplied the synopsis. 19 witnesses. My lords, PW1 is one Babu. Yes, ma'am. Yes, yes. PW1, my lords, is one Babu Rajesh Saab Madhapur. My lords, he's a,
Just read complaint once.
yes, my
Exhibit
lords.
P. This lodged by PW2,
Yes, my lords, PW2, the injured. It is at page number 3, my lords. ನಾನು ಹುಸೇನ್ ಬಿ ಗಂಡ ಉಮ್ರಾ ಮಕಾಂದರ್ ವಯಸ್ಸು ಸೋಯನ್ಸು ಸಾಕಿನ್ ಉದ್ಯೋಗ ಮದ್ರಸಾದಲ್ಲಿ ಅಡಿಗೆ ಕೆಲಸ ಇಂಡಿ. ನಾನು ಮೇಲೆ ಹೇಳಿದ ವಿಳಾಸದವಳಿದ್ದು ಇಂಡಿ ಪಟ್ಟಣದ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಹತ್ತಿರ ಇರುವ ಮದ್ರಸಾ ಸ್ಕೂಲ್ನಲ್ಲಿ ಸುಮಾರು 3 ವರ್ಷಗಳಿಂದ ಅಡಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದೆ. ನನ್ನಂತೆ ಸಿಂದಗಿ ತಾಲೂಕಿನ ಕಡ್ನಿ ಗ್ರಾಮದ ರಿಹಾನಾ ತಂದೆ ಅಬ್ದುಲ್ ಮೊರಟ್ಗಿ, ತಂದೆಗಿಂತ ಗಂಡ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ, ಮೊರಟ್ಗಿ ಇವಳು ಸುಮಾರು 1 ವರ್ಷಗಳಿಂದ ಅಡುಗೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುತ್ತಾಳೆ. ಅವಳು ತವರು ಮನೆ ಇಂಡಿ ಇದ್ದು ಗಂಡನ ಮನೆಯು ಸಿಂದಗಿ ತಾಲೂಕಿನ ಕಡ್ನಿ ಗ್ರಾಮವಿರುತ್ತದೆ. ಅವಳು ಮದುವೆಯಾಗಿ 10-12 ವರ್ಷಗಳಾಗಿರುತ್ತದೆ. ಈ ನಡುವೆ ಅವಳಿಗೆ ಸುವೆನ್ಸೋ ಅಂತಹ ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ಈಗ ಸುಮಾರು 3 ವರ್ಷಗಳಿಂದ ಅವಳು ಗಂಡನ ಮನೆಯಲ್ಲಿ ಜಗಳ ಮಾಡಿ ತನ್ನ ಮಕ್ಕಳಿಗೆ ಕರೆದುಕೊಂಡು ಗಂಡನಿಗೆ ಬಿಟ್ಟು ಇಂಡಿಯಲ್ಲಿ ಇದ್ದು ಆಗಾಗ ಅವಳ ಗಂಡ ಅಬ್ದುಲ್ ಮೊರಟ್ಗಿ ಸೋಯನ್ಸೋ ಈತನು ಇಂಡಿಗೆ ಬಂದು ವಿನಾಕಾರಣ ಅವಳೊಂದಿಗೆ ಜಗಳ ಮಾಡುವುದು, ನೀನು ಅಡುಗೆ ಮಾಡುವ ಮದ್ರಸಾದಲ್ಲಿ ಮೌಲಾನಾಗಳ ಜೊತೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದಿ ಅಂತ ಜಗಳ ಮಾಡುವುದು, ಕಿರಿಕಿರಿ ಮಾಡುವುದು, ಹೊಡಿಬಡಿ ಮಾಡುವುದು ಮಾಡುತ್ತಿದ್ದನು. ಇಂದು ದಿನಾಂಕ 24/9/2015 ರಾತ್ರಿ 8 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ಮತ್ತು ರಿಹಾನಾ ಮೊರಟ್ಗಿ ಇಬ್ಬರು ಕೂಡಿ ಮದ್ರಸಾದಲ್ಲಿರುವ ಅಡಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು, ರಿಹಾನಾ ಇವಳ ಗಂಡ ಅಬ್ದುಲ್ ಮೊರಟ್ಗಿ ಸಾಕಿನ್ ಕಡ್ನಿ ಈತನು ತನ್ನ ಕೈಯಲ್ಲಿ ಕೊಡ್ಲಿ ಹಿಡಿದುಕೊಂಡು ಬಂದವನೇ ರಿಹಾನಾ ಇವಳಿಗೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ರಂಡಿ ನನಗೆ ಬಿಟ್ಟು ಮೌಲಾನಾಗಳ ಜೊತೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿ ಮದ್ರಸಾದಲ್ಲಿ ಇದ್ದಿದ್ದಿ ಅಂತಹ ಅಂದು ಅವಳಿಗೆ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ತನ್ನ ಕೈಯಲ್ಲಿಯ ಕೊಡ್ಲಿಯಿಂದ ಹೊಡೆಯಲಿಕ್ಕೆ ಹತ್ತಿದನು. ಅದನ್ನು ನೋಡಿ ನಾನು ಜಗಳ ಬಿಡಿಸಲು ಅಂತಹ ಬಂದಾಗ ನೀನು ಜಗಳ ಬಿಡಿಸಾಕ ಬರ್ತೀಯ ರಂಡಿ ಅಂತ ಹಲ್ಕಟ್ ಬೈದು ಸಹ ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಕೊಡ್ಲಿಯಿಂದ ಎಡಗಾಲು ಮೊಳಕಾಲು ಕೆಳಗಡೆ ಮತ್ತು ಎಡಗೈ ತೋರು ಬೆಳಗ್ಗೆ ಹಾಗೂ ಮಧ್ಯ ಬೆರಳಿಗೆ ಕೊಡ್ಲಿಯಿಂದ ಹೊಡೆದನು. ಇದರಿಂದ ನಾನು ಕಾಲಿಗೆ ಮತ್ತು ಕೈಗೆ ಭಾರಿ ಗಾಯವಾಗಿ ರಕ್ತ ಬರಲಿಕ್ಕೆ ಹತ್ತಿತ್ತು. ನಮ್ಮ ಜಗಳವನ್ನು ನೋಡಿದ ಮದ್ರಸಾದಲ್ಲಿರುವ ಮೌಲಾನಾಗಳು ಬಂದು ಜಗಳ ಬಿಡಿಸಿ ಕಳಿಸಿದರು. ಅವನು ಹೋಗುವಾಗ ಈಗ ಉಳಿದಿರಿ, ಇನ್ನೊಮ್ಮೆ ನಿಮಗೆ ಬಂದು ಖಲಾಸ್ ಮಾಡುತ್ತೇನೆ ಅಂತ ಜೀವದ ಬೆದರಿಕೆ ಹಾಕುತ್ತಾ ಹೋದನು. ನಂತರ ನಮಗೆ ಮದ್ರಸಾದಲ್ಲಿರುವ ಜನರು ಉಪಚಾರದ ಸಲುವಾಗಿ ಇಂಡಿಯ ಸ್ಪಂದನ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲ್ ಮಾಡಿದರು. ಡಾಕ್ಟರ್ ಉಪಚಾರ ಮಾಡಿ ರಿಹಾನಾ ಇವಳಿಗೆ ತಲೆಗೆ ಬಲವಾದ ಗಾಯವಾಗಿ ರಕ್ತ ಬರುತ್ತಿರುವುದರಿಂದ ವಿಜಾಪುರ ಆಸ್ಪತ್ರೆಗೆ ಕಳಿಸಿದರು. ಸದ್ಯ ನಾನು ಇಂಡಿ ಸ್ಪಂದನ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಉಪಚಾರ ಪಡೆಯುತ್ತಿದ್ದೇನೆ. ಈ ಬಗ್ಗೆ ಆಸ್ಪತ್ರೆಗೆ ಬಂದು ದಾಖಲಾಗಿ ಅಬ್ದುಲ್ ಮೊರಟ್ಗಿ ಸಾಕಿನ್ ಕದ್ನಿ ಈತನ ಮೇಲೆ ಫಿರ್ಯಾದಿ ಕೊಡಲು ತಡವಾಗಿರುತ್ತದೆ. ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲು ವಿನಂತಿ. So this is the complaint which she would give, my lords.
Who are the Maulanas rescued? ಜಗಳವನ್ನು ನೋಡಿದ ಮದ್ರಾಸ್ನಿಂದ ಮೌಲಾನ ಬಂದು ಜಗಳ ಬಿಡಿಸಿ.
My lords, they are, my lords, CW 8 to 10, 12, my lords. They have been examined as PW 5 and 6, my lords. 5 and 6. And a student by name Fayaz, who was also there, my lords, who was examined as PW 7, has also been examined, my lords. But he has not supported.
5 and 6 are supported.
Yes, my lords, they have supported.
Now what is the evidence of PW2?
Yes, my lords, evidence. Now, my lords, the trial court would mainly rely on the evidence of injured PW2 complainant. Holds that since she is an injured witness and
Not disputing the death.
yes, my lords. Rather, I don't have any option, my lords. So, my lords, PW2, 5 and 6 are the witnesses which the the prosecution mainly relies, and even the trial court, placing heavy reliance on their evidence, has, my lords, come to the conclusion that it is the appellant and appellant alone who has committed the murder. Now, my lords, the question is, my lords, the evidence, I would read the evidence of PW2, my lords. It is at page number 62, my lords. Whose
Weapon used for the commission of crime, axe.
yes, my lords.
Seized from the spot or?
No, my lord. It was recovered after 2 months, more than 2 months, from an open place, besides the madrasa only. I'll come to that aspect later. That has been recovered at the instance of the accused. As per exhibit Exhibit P4, my lords.
Yes. Now come to the evidence, PW2.
2's evidence, page number 62, my lords, of the paper book. 62. Para 2 ಲಿಂದ I'll just read. ನಾನು ಮತ್ತು ಮೃತ ರೆಹಾನ ಇಂಡಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಹತ್ತಿರ ಇರುವ ಮದ್ರಸಾದಲ್ಲಿ ಅಡಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಚಾಸ 9 ರಿಂದ 12ರವರು ನಂಬರ್ 62 ನೋಟ್ಸ್. ಪ್ಯಾರಾ 2. ಚಾಸ 9 ರಿಂದ 12ರವರು ಮದ್ರಸಾ ಶಾಲೆಯಲ್ಲಿ ಶಿಕ್ಷಕರಾಗಿರುತ್ತಾರೆ. ಚಾಸ 8 ಫಯಾಜ್ ಮದ್ರಸಾದ ವಿದ್ಯಾರ್ಥಿ. ದಿನಾಂಕ 24/9/2017 ರಾತ್ರಿ 8 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ಮತ್ತು ಮೃತ ರೆಹಾನ ಮದ್ರಸಾದಲ್ಲಿ ಅಡುಗೆ ಕೋಣೆಯಲ್ಲಿ ಅಡುಗೆ ಮಾಡುತ್ತಿದ್ದೆವು. ಆ ಸಮಯದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆರೋಪಿ ರಿಹಾನಾಳ ಗಂಡ ಕೊಡ್ಲಿ ಹಿಡಿದುಕೊಂಡು ಅಡುಗೆ ಕೋಣೆಯಲ್ಲಿ ಬಂದು, ಏ ರಂಡಿ, ನನ್ನನ್ನು ಬಿಟ್ಟು ಇಲ್ಲಿ ಏಕೆ ಬಂದಿ ಎಂದು ರಿಹಾನಾಳ ತಲೆಗೆ ಹೊಡೆದನು. ನಾನು ರಿಹಾನಾಳನ್ನು ಏಕೆ ಹೊಡೆದಿ ಎಂದು ಪ್ರಶ್ನಿಸಲಾಗಿ, ನನಗೂ ಸಹ ನನ್ನ ಎಡಗೈ ಬೆರಳಿಗೆ ಮತ್ತು ಎಡಕಾಲು ಬೆರಳುಗಳಿಗೆ ತಾನು ಹಿಡಿದುಕೊಂಡು ಬಂದ ಕೊಡ್ಲಿಯಿಂದ ಹೊಡೆದಿರುತ್ತಾನೆ. ನನ್ನ ಎಡಗೈಯಿನ ತೋರು ಬೆರಳು ಮತ್ತು ಮಧ್ಯದ ಬೆರಳು ಕತ್ತರಿಸಿದ್ದು ಎಡಕಾಲಿನ ಮಂಡಿಯ ಕೆಳಭಾಗದಲ್ಲಿ ಕೊಡ್ಲಿ ಪೆಟ್ಟು ಬಿದ್ದಿತ್ತು. ರೆಹಾನಾಳಿಗೆ ತಲೆಯ ಮೇಲೆ 3 ಸಲ ಹೊಡೆದಿದ್ದರಿಂದ ಪೆಟ್ಟು ಬಿದ್ದಿರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ನೋಟ್ಸ್. ಶಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಸೇಸ್ ರೆಹಾನಾಳಿಗೆ ತಲೆಯ ಮೇಲೆ 3 ಸಲ ಹೊಡೆದಿದ್ದರಿಂದ ಪೆಟ್ಟು ಬಿದ್ದಿರುತ್ತದೆ. ಘಟನಾ ಸ್ಥಳದಲ್ಲಿ ರಕ್ತ ಬಹಳವಾಗಿ ಬಿದ್ದಿತ್ತು. ನಾವು ನೋವಿನಿಂದ ಚೀರಾಡಿದಾಗ ಮದ್ರಸದ ಶಿಕ್ಷಕರು ಮತ್ತು ವಿದ್ಯಾರ್ಥಿಗಳು ಓಡಿ ಬಂದಿದ್ದನ್ನು ನಾನು ಮತ್ತು ನನ್ನನ್ನು ಮತ್ತು ರಿಹಾನಾಳನ್ನು ಇಂಡಿ ಪಟ್ಟಣದ ಸ್ಪಂದನ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ನೋಟ್ಸ್, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ನೋಟ್ಸ್. ಐ ವಿಲ್ ರೀಡ್ ಇಟ್ ಅಗೇನ್. ನಾವು ನೋವಿನಿಂದ ಚೀರಾಡಿದಾಗ ಮದ್ರಸದ ಶಿಕ್ಷಕರು ಮತ್ತು ವಿದ್ಯಾರ್ಥಿಗಳು ಓಡಿ ಬಂದು ನನ್ನನ್ನು ಮತ್ತು ರಿಹಾನಾಳನ್ನು ಇಂಡಿ ಪಟ್ಟಣದ ಸ್ಪಂದನ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ಸೊ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿಸ್ ವಿಟ್ನೆಸ್, what transpired on the day of incident was the appellant armed with the axe would come to the place of work, assault the deceased, and in fact assault the complainant. And when they would raise the alarm, it is only then the other witnesses come, Lords. The teachers, PW 5 and 6.
Then the accused must be there.
Yes, madam.
Even then, the accused must be there in the spot.
Yes, madam. Yes. So my respectful submission is that, Lords, so far as PW 5 and 6 can be termed as material witnesses, they might have seen the accused armed with the axe and fleeing the place after the assault, Lords, because
yes,
that is what can be concluded or inferred is that, Lords. Let us come to this. Now, Lords, rest all parts.
Before that, see, the evidence of PW1, ರಿಯಾನನ ತಲೆಯ ಮೇಲೆ 3 ಸಲ ಹೊಡೆದದ್ರಿಂದ ಪೆಟ್ಟು ಬಿದ್ದಿರುತ್ತದೆ. What is their statement in this one complaint? What is her say in the complaint?
Complaint ನಲ್ಲಿ ಆ ತರ ಏನು no specific numbers are stated. She says that he has assaulted. Yes, my lords. I've just
Page number 4, my lords.
4.
My lords. 6th line.
ಉದ್ದೇಶದಿಂದ ರಂಡಿನನ್ನು ಬಿಟ್ಟು ಮೌಲಾನಾ ಜೊತೆ ಅನೈತಿಕ ಸಂಬಂಧ ಹೊಂದಿದ್ದಕ್ಕೆ
ಹತ್ತಿದನು
ಅಂತ ಅವಳಿಗೆ
ಕೊಡಲಿಯಿಂದ ಹೊಡೆಯಲಿಕ್ಕೆ ಹತ್ತಿದನು.
He started assaulting her. She would not give the specific number.
Repeated blow.
Yes, she says that he has repeatedly assaulted him. Now, my lords, for a moment, my lords, now if we see the medical evidence, which is at exhibit P20, the postmortem report, my lords, it can be found at page number 42, my lords. That is I have read out the relevant portion of the evidence. Rest all may not be, it's about lodging of complaint. So far as the incident I have read out. Request my lords to kindly turn to page number 42, exhibit P20. P20, more particularly page number 43, my lords. External appearance, injuries, cut lacerated wound over the vertex, lying posteriorly measuring 14 centimeters into 3 centimeters, skull deep. Second injury, abrasion over the left big toe at the medial aspect. Lords, the second injury, my lords, appears to be
These 2 injuries.
only 2 injuries. That too in second injury, it's an aberration where a person can fall and get her the big toe, which the left big toe, my lords, where she has sustained some abrasion. So technically, or if we go by the record, my lords, there is only one injury, my lords. One injury on her vertex. That is on the middle of the skull portion.
What is the say of this doctor? Doctor,
my lords, his evidence, he is examined as PW 15, my lords. He would say that the injury has resulted in death.
Injuries anta single injury anta heltara avaru.
Single injury, yes, my lords. He says only single injury. Single injury, my lords.
Dr. Rajesh Kolekara.
16.
Yes, my lords.
PW 15 or 16?
16.
16.
16, Dr. Ashok.
Ashok Kumar.
Yes.
He reiterates the content. Same.
Yes, same to same. So, my lords, and curiously, my lords, his evidence.
ನನ್ನ ಅಭಿಪ್ರಾಯದಲ್ಲಿ ಮರಣವು ತಲೆಯ
ಭಾಗದಲ್ಲಿ ಆದ ಗಾಯಗಳಿಂದ ಕೋಮಾ ಸ್ಥಿತಿ ತಲುಪಿ ಮರಡು ಉಂಟಾಗಿರುತ್ತದೆ. ಈಗ ನಾನು ನೀಡಿದ ಮರಣೋತ್ತರ ಪರೀಕ್ಷೆ ವರದಿಯನ್ನು ನಿಶಾನೆ P20 ಮತ್ತು ಅದರ ಮೇಲಿರುವ ಸಾಕ್ಷಿ ಸಹಿಯನ್ನು ನಿಶಾನೆ P20A ಅಂತ ಗುರುತಿಸಲಾಯಿತು. So, my lords, essentially, my lords, as my lords have seen, or
ಎಷ್ಟು ಗಾಯಗಳಂತ ಇಂಜುರೀಸ್ ಎಷ್ಟು ಅಂತ ಹೌ ಮೆನಿ ಇಂಜುರೀಸ್ ದೇರ್ ಅಂತ ಎಕ್ಸಾಮ್ ಕೇಳಲಿಕ್ಕಿಲ್ವಾ ಡಾಕ್ಟರ್ ಅಲ್ಲಿ ಕೇಳಲಿಕ್ಕಿಲ್ವಾ ಎಷ್ಟು ಇಂಜುರಿ ಆಗಿದೆ ತಲೆ ಭಾಗದಲ್ಲಿ ಏನೇನಾಗಿದೆ ಅಂತ?
According to this doctor, there is one injury, my lords. Whatever he has stated in the autopsy report, he, my lords, has reiterated before the court. And he specifically...
ಗಾಯಗಳಿಂದ
my lords, that it... Then, my lord, now going by that also, my lords, there should be more injuries. The injury to the toe can never be fatal. Let us, assuming that the entire toe itself is cut, even then it can't be fatal. So, and moreover, my lords, the injuries, the second injury, abrasion over the left big toe at the medial aspect, my lords, hardly can be a injury which can be caused by the axe. If a person is assaulted on the toe itself, even then abrasion will not be caused. It's a sharp-edged weapon. What we can get is an incision, my lords, or cut lacerated wound. And this is not a cut laceration. So, my lords, it appears that maybe while falling down, she might have sustained that injury, my lords.
But look at the 14 centimeter into
3 centimeters. That is the, yes, my lords, I'll come to that. So, according to the eyewitness, firstly in the complaint, she says that the accused has repeatedly assaulted her. Repeatedly. Hodiyuttidanu. And then in the evidence, she would make an improvement, though may not be material, as my friend may say. She specifically says that once she would assault him, when the complainant would intervene, after that, my lords, he would assault her 3 times on her head. But however, what belies her evidence before the court is the exhibit P20, the post-mortem report, which says that there was only one injury. So, my lords, my respectful submission is, my lords, that what is presented before the court may be a subversion of the incident, may not be the actual version. So, my submission is, my lords, when the incident in question, according to, my lords, that is why, my lords, when I submitted, when the complainant was injured, I may not have, it is very tough for me to overcome her evidence. Now, but what my submission would be, my lords, that what she is presenting may not be the entire truth. So, my lords, my submission is that considering the totality of circumstance, considering their the upbringing, the social pattern, because both are Mohammedans, they are, my lords, from a conservative community. Husband, my lords, and it is their case that husband was repeatedly suspecting she had left him. She was working as a cook and he was suspecting her. So, my lords, even before the incident, it appears that there was some commotion or some argument between the parties. And there, my lords, that triggered the accused and he has assaulted her, can be the version. So, my lords, I am primarily pitching on the fact that the case as understood or presented by the prosecution may fall under the ambit of 304 part 1, my lords. It would amount to culpable homicide. Whether it is murder or not, my lords, I'll demonstrate. Now, my lords, primarily when
But then you'll have to make out a case, one blow,
single blow, it is a case of single blow.
one blow on a vital part.
Yes, I understood, my lords, what the court.
So try, make out your case, how? Now, the additional SPP is saying, it's not like Nanavati's case that she was there with.
Yes, my lord.
That's his argument.
Yes, my lord, certainly.
So grave and sudden provocation goes.
May not.
Now, if you are trying to say it has to come down, one vital blow on a vital part may be sufficient is what he's saying. How do you get over that?
Yes, my lord. My submission would be, my lords, where, my lords, where the actual incident may not be what is presented may not be the correct version, then, my lords, it automatically, my lords, would have some scope for getting it under a lesser offense. In this regard, my lords, I would want to rely on a judgment. Lords, it was a appeal. Lords, it was an appeal. It was an appeal where the appellant was convicted on the count of murder. Now, my lords, the matter went up to Honorable Supreme Court, and para 5, my lords, para 5 would be a. The circumstances that appear are that there is no clear explanation of the injuries to the accused person. The appellant has set up a defense that a scuffle started, and it is only then the situation that he took out the knife and inflicted the blow. It is also not in dispute that it was only one blow which was inflicted by the present appellant. In these circumstances, the evidence of the prosecution does not clearly establish the manner in which the incident took place, and therefore it could not be held that the incident did not take place in the manner suggested by the present appellant accused, and in that situation it could be held that he inflicted the injuries with an intention to cause death. At best, the knowledge could be imputed to him that may result in the death. In view of this conviction, the appellant under section 302 could not be maintained. The conviction of the appellant is altered to 304 part 2. So, my lords, where the submission would be, my lords, that where the incident, the manner of incident is not clearly stated, there, my lords, the accused would get the manner in which the incident took place has not been properly stated, or maybe stated by the witnesses. According to the complainant, who is an injured witness, she would, my lord, state that he has assaulted her repeatedly, many times, more particularly after having assaulted the complainant 3 times. Now, however, as I have submitted, the post-mortem report would suggest that there was only one injury. Now, so my submission would be, my lords, the incident, the manner of incident has not been properly stated by the witnesses. And this witness specifically states that upon being assaulted and when they were shouting in agony, it is only then the other witnesses would come. And even their evidences spell out the same, my lords. They say that upon hearing the deceased and the complainant, they came from their rooms. So certainly, my lords, they would not, PW 4 and 5 would not have witnessed the incident of assault. They can at the most be material witnesses. They might have seen the accused armed with the axe, the weapon of the incident, running away from the place. But they certainly could not have seen the act of assault.
Their evidence also believable. Otherwise, rest just day. They immediately they visited. this
Adukine
spot.
Swami, my submission would be, lords, it can be under section 304 part 1. Now
For that, now tell us one thing. Say, ಕೊಡಲಿಯಿಂದ ರಿಪೀಟೆಡ್ ಹೊಡೆದನು, ಹೋಗುವಾಗ ನಿಮ್ಮನ್ನು ಈ ಸಾರಿ ಬದುಕಿದ್ರಿ, ನೆಕ್ಸ್ಟ್ ನಿಮ್ಮನ್ನು ಬಿಡಲ್ಲ, ಮತ್ತೆ ಬಂದು ನಿಮ್ಮನ್ನು ಸಾಯಿಸ್ತೇನೆ. See the intention.
Lords, and the death is not instantaneous.
Wife, but also to PW2.
Yes, Lord.
See the conduct.
Death is not instantaneous, Lords. The deceased died the next day.
Next day in the sense, no, the incident is at about 8:30, 8 a.m.
8 a.m. She dies the next day evening around 5:30, Lords.
Next day.
Next day.
Morning.
While treating.
And one more reason, Lords. Kindly see the evidence of doctor, Lords. Examination chief itself, Lords. The doctor does not say that the injury so sustained or caused would in the natural course would result in the death, Lords. That part of the evidence the doctor will have to state. Page number 98, Lords. I'll just read out the examination chief notes. Para 4. ಉಳಿದ ಭಾಗಗಳು ಸುಸ್ಥಿತಿಯಲ್ಲಿದ್ದವು. ಮೇಲೆ ಹೇಳಿದ ಎಲ್ಲಾ ಹೊರಗಾಯಗಳು ಮರಣಪೂರ್ವ ಗಾಯಗಳಾಗಿರುತ್ತವೆ. ಮರಣವು ಪರೀಕ್ಷಾ ಅವಧಿಯಿಂದ 12 ರಿಂದ 24 ಗಂಟೆ ಅವಧಿಯ ಒಳಗೆ ಸಂಭವಿಸಿರಬಹುದು. ನನ್ನ ಅಭಿಪ್ರಾಯದಲ್ಲಿ ಮರಣ ತಲೆಯ ಭಾಗದಲ್ಲಿ ಆದ ಗಾಯಗಳಿಂದ ಕೋಮಾ ಸ್ಥಿತಿಗೆ ತಲುಪಿ ಮರಣ ಉಂಟಾಗಿರುತ್ತದೆ. ಈಗ ನಾನು ನೀಡಿದ ಮರಣೋತ್ತರ ಪರೀಕ್ಷಾ ವರದಿಯನ್ನು ನಿಶಾನೆ P20 ಮತ್ತು ಅದರ ಮೇಲೆ ಇರುವ ಸಾಕ್ಷಿದಾರರ ಸಹಿಯು ನಿಶಾನೆ P20A ಅಂತ ಗುರುತಿಸಲಾಯಿತು. ನಂತರ ಪೊಲೀಸರು ದಿನಾಂಕ 30/12/2015 ಸಿಬ್ಬಂದಿಯೊಂದಿಗೆ ಒಂದು ಸೀಲ್ ಮಾಡಿದ ಕೊಡ್ಲಿಯನ್ನು ಪರೀಕ್ಷೆಗೆ ಕಳುಹಿಸಿ ನನ್ನ ಅಭಿಪ್ರಾಯ ಕಳುಹಿಸಿದರು. ನಾನು ಸದರಿ ಕೊಡ್ಲಿಯನ್ನು ಪರೀಕ್ಷಿಸಿ PM ವರದಿಯಲ್ಲಿ ನಮೂದಿಸಿದ ಗಾಯಗಳು ಪರೀಕ್ಷೆಗೆ ಕಳುಹಿಸಲ್ಪಟ್ಟ ಕೊಡ್ಲಿಯಿಂದ ಆಗಿರಬಹುದು ಎಂದು ಪ್ರಮಾಣ ಪತ್ರ ನೀಡಿರುತ್ತೇನೆ. ಅದನ್ನು ನಿಶಾನೆ P21 ಮತ್ತು ಅದರ ಮೇಲಿರುವ ಸಾಕ್ಷಿದಾರ ಸಹಿಯನ್ನು ನಿಶಾನೆ P21A ಅಂತ ಗುರುತಿಸಲಾಗಿದೆ. ಕೊಡ್ಲಿಯಿಂದ ನೋಡಿ ಗುರುತಿಸಿದ್ದು ಅದನ್ನು ಈಗಾಗಲೇ So he nowhere says that the injury would naturally result in the death, Lords. Now, in this regard, Lords, I would want to rely on the judgment of Honorable Supreme Court.
Within 24 hours, Mr. Nagali. Tell me within 24 hours. Yeah. What is the requirement of, what is the necessity?
Judgment reported in 2007, part 1 SEC criminal page number 66. Bunilal Chaudhary versus State of Uttar Pradesh. Even here, my lords, there was a case of single blow to the chest. Para 10 would be the page where, my lords, it was discussed. May I read, my lords? We have given our thoughtful and anxious consideration to the rival contentions of the learned counsel. The next question is, what is the offense which is brought home to Bunilal Chaudhary? It is not in dispute that the injury inflicted on the left side of the chest of the deceased is a single one. On examination, Dr. Vijay Kumar found the injury situated above the nipple on the left side of the chest, extending 1 inch into half an inch, penetrating wound. On dissection, the left lung was found penetrated. Dr. Vijay Kumar has not opined that the injury was sufficient in the ordinary course of nature to cause death. That was not even stated to be likely to cause death. No attempt was made by Bunilal Chaudhary to cause injuries, serious injuries on any vital part of the body of the deceased. There was no motive or intention of the Bunilal Chaudhary to have murdered Shambhu Rawat. Therefore, the question is whether the offense can be said to be covered by clause 3 of section 300 of IPC 11. That section requires that bodily injury must be intended, and the bodily injury intended to be caused must be sufficient in the ordinary course of the nature to cause death. This clause is in two parts. The first part is the subjective one, which indicates that the injury must be an intentional one and not an accidental one. The second part is objective in that looking at the injury intended to be caused, the court must be satisfied that it was sufficient in the ordinary course of the nature to cause death. We find that the first part is complied with because the injury which was intended to be caused was the one which was found on the person of Shambhu Rawat. But the second part, in our opinion, is not fulfilled because, but for the fact that the injury caused had penetrated the lung, death might not have ensued. In other words, looking at the matter objectively, the injury which Bunilal Chaudhary intended to cause did not include specifically the cutting of left lung, but to wound Shambhu Rawat in the neighboring hood of the nipple on the left side of the chest. Therefore, we are of the opinion that the clause 3 of section 300 does not cover the case, in as much as the death as caused, the matter must still come within at least the culpable homicide not amounting to murder. There again, section 299 is in 3 parts. So they have explained those.
Law in this case, come to para 8.
Yes, ma'am.
Last line. The injuries were antemortem in nature, caused within 24 hours of the examination. What is remarkable is that Dr. Vijay Kumar could not ascertain the cause of death. In this case, he is not ascertain the cause of death. Wherein, of course, in the evidence of PW 18, PW
16.
Not stated. But fact remains the PM report, the PM
20.
report, exhibit P20 said death was due to cause of head injury.
Head injury.
Yes. So in this case, it is not ascertained at all the cause of death. What is the cause of death? Yes, this is then the manner in which the prosecution has conducted a criminal trial, that too in a murder case.
Furthermore, my lords, the
This you can show that the injury where it is caused, vortex or whatever.
vertex.
That normally, if you injure that part, this consequence won't result. If you are able to show something like that, some literature to that effect, then we may be able to take your stand. So now you have to answer. Suppose the injury is caused. Normally, that injury will not result in death, though in this case it has resulted in death. If you can show something like that, then we can see.
Yes.
That this injury to that vortex.
Vertex, yes.
Is it some medical literature to show that if this injury happens, death normally will happen? It's a vital part. Can you show otherwise is what you have to establish?
Yes, I'll clarify. So far as recovery, my lords, recovery of acts. PW3, my lords, Chandrakant Krishna Pawar, my lords, is the witness who speaks regarding recovery of acts. May I submit, my lord, may I read the portion of his evidence, my lords?
Yes. PW 3,
3, my lords. Page number 65. Chasa Yolu Anil ಸೊ ಇವರು ಪರಿಚಯ ಇರುತ್ತದೆ. ದಿನಾಂಕ 22/11/2015 ಮಧ್ಯಾಹ್ನ 1 ಸುಮಾರಕ್ಕೆ ನನ್ನನ್ನು ಮತ್ತು ಚಾಸಾಯೋಳು ಅನಿಲ್ ಇವರಿಗೆ ಇಂಡಿ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಕರೆಸಿದರು. ಠಾಣೆಯಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆರೋಪಿ ಹಾಜರಿದ್ದರು. ಆರೋಪಿಯು ನಮ್ಮ ಮುಂದೆ ನನ್ನ ಜೊತೆ ಬಂದರೆ ಕೊಡ್ಲಿ ಹಾಜರುಪಡಿಸುವುದಾಗಿ ತಿಳಿಸಿದನು. ನಾನು ಅನಿಲ್, ಆರೋಪಿ ಮತ್ತು ಪೊಲೀಸ್ ವಾಹನದಲ್ಲಿ ಆರೋಪಿ ತೋರಿಸಿದ ಸ್ಟೇಷನ್ ರೋಡಿನಲ್ಲಿ ಇರುವ ಮದರಸಾದ ಹತ್ತಿರ ಹೋಗಿದ್ದೆವು. ಅಲ್ಲಿ ಒಂದು ಹೊಲದಲ್ಲಿ ಮುಚ್ಚಿಟ್ಟಿದ್ದ ಕೊಡ್ಲಿಯನ್ನು ಆರೋಪಿಯು ತಂದು ನಮ್ಮ ಸಮಕ್ಷಮ ಪೊಲೀಸರಿಗೆ ಹಾಜರುಪಡಿಸಿದನು. ಅದನ್ನು ಪೊಲೀಸರು ಪಂಚನಾಮೆ ಮಾಡಿ ಜಪ್ತಿ ಮಾಡಿಕೊಂಡು ಮತ್ತು ಆ ಪೊಲೀಸರು ಫೋಟೋ ತೆಗೆದಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ರೆಲೆವೆಂಟ್ ಪ್ರೊಸೀಜರ್. Now, my lords, my respectful submission to make anything, lords, admissible under section 27 of Evidence Act, what is required is a discovery of fact. My lords, anything which is in open and accessible place can never be discovered. The exclusive knowledge of the accused makes that information admissible, my lords. My lords, generally, my lords, the recovery is based on a philosophy of doctrine of subsequent events, my lords. This is the philosophy where what assures or the lends credence to the recovery is, my lords, the exclusive knowledge of the accused. And there are certain requirements that the accused should be in custody. Accused should be accused of an offense. He should be in custody. And while in custody, he should have confessed. And based on that confession, there should be some recovery. That should have led to a recovery of a distinct matter in issue, my lords. Not the other matter, distinct, directly resulting. So, my lords, in this regard, my lords, now anything which is in open or things which are already known can never be recovered.
How you can say that? See, what he has stated, ಆರೋಪಿ ಹಾಜರಿದ್ದರು, ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆರೋಪಿ ಹಾಜರಿದ್ದ, ನಮ್ಮ ಜೊತೆ ಬಂದ್ರೆ ಕೊಡಲಿ ಹಾಜರುಪಡಿಸುವುದಾಗಿ ತಿಳಿಸಿದ್ದ.
Yes,
ಮದ್ರಾಸ್ ಹತ್ತಿರ ಹೋಗಿದ್ದೆವು, ಹೊಲದಲ್ಲಿ ಮುಚ್ಚಿಟ್ಟಿದ್ದ ಕೊಡಲಿ.
Lords, ಹೊಲದಲ್ಲಿ where he should speak out the details where
is in Bazrak.
ಇಲ್ಲ, lords, it is an open field. It is not some small space, lords. It is an open big field. Access is
Exhibit P4 note.
Yes.
Page number 23.
That even as per the Shankar case or Bobby case only, they clearly said station indle bandaddu anta karkondu.
No, lords, my submission is he has to specifically state from where it was recovered. It is not that they go and he gets it. They'll have to state.
Come to exhibit P4.
P4, page number 23 minutes. ಈ ದಿವಸ ಇಂಡಿ ವೃತ್ತಿಯ ಸಿಪಿಐ ಸಾಹೇಬರು ನಮ್ಮನ್ನು ಪಂಚರು ಅಂತಹ ಇಂಡಿ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಕರೆಸಿ ಇಂಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಗುನೆ ನಂಬರ್ ಸೋನ್ಸೋನೇ ಪ್ರಕರಣದಲ್ಲಿ ದಸ್ಗೀರಾದ ಆರೋಪಿತನ ಹೆಸರು ಕೇಳಿ ಅವನು ಏನು ಹೇಳಿ ಏನು ತೋರಿಸಿ ಹಾಜರು ಮಾಡುತ್ತಾನೆ ಎಂಬುದು ಬಗ್ಗೆ ಸಮಕ್ಷಮ ನೋಡಿ ಕೇಳಿ ಹೇಳಿ ಪಂಚನಾಮೆಯನ್ನು ಬರೆಸಿಕೊಡಲಿಕ್ಕೆ ಕೇಳಿಕೊಡುವ ಮೇರೆಗೆ ಅದಕ್ಕೆ ನಾವು ಪಂಚರಾಗಲು ಒಪ್ಪಿಕೊಂಡೆವು. ಸಮಕ್ಷಮ ದಸ್ಗೀರಾಗಿ ಸಿಪಿಐ ಸಾಹೇಬರ ವಶದಲ್ಲಿ ಆರೋಪಿತನ ಹೆಸರು ಕೇಳಲು ಅವನು ತನ್ನ ಹೆಸರು ಅಬ್ದುಲ್ ಲಾಲ್ಸಾಬ್ ಮೊರಡ್ಗಿ, ವಯಸ್ಸು ಸೋನ್ಸೋ, ತಾಲೂಕ್ ಸಿಂದಗಿ ಅಂತ ಹೇಳಿದ್ದು ನಾವು ಕೂಡಲೇ ಸದರಿ ಆರೋಪಿತನಿಗೆ ಗುನ್ನೆ ಹಕೀಕತ್ ವಿಚಾರಿಸಲಾಗಿ ಆತ ತಾನು ತನ್ನ ಹೆಂಡತಿಯಾದ ರಿಹಾನಾ ಇವಳನ್ನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ದಿನಾಂಕ 24/9/2015 ರಾತ್ರಿ 8 ಗಂಟೆ ಸುಮಾರಿಗೆ ಇಂಡಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಹತ್ತಿರ ಇರುವ ಮದರಸಾ ಶಾಲೆಯ ಅಡಿಗೆ ಕೋಣೆಯಲ್ಲಿ ಹೋಗಿ ಕೊಡ್ಲಿಯಿಂದ ತನ್ನ ಹೆಂಡತಿಯ ತಲೆಗೆ ಬಲವಾಗಿ ಹೊಡೆದು ಭಾರೀ ಗಾಯಗೊಳಿಸಿದ್ದಲ್ಲದೆ ಬಿಡಿಸಲು ಬಂದ ಹುಸೇನ್ ಬಿ ಸೋನ್ಸೋ ಇವಳಿಗೂ ಸಹ ಅದೇ ಕೊಡ್ಲಿಯಿಂದ ಅವಳ ಎಡಗೈ ಮತ್ತು ಮೊಳಕಾಲು ಕೆಳಗಡೆ ಹೊಡೆದು ಗಾಯಗೊಳಿಸಿ ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದಾನೆ. ಸಂಗಡ ಬಂದರೆ ತಾನು ಕರೆದುಕೊಂಡು ಹೋಗಿ ಗುನ್ನೆಗೆ ಬಳಸಿದ ಕೊಡ್ಲಿಯನ್ನು ತೋರಿಸಿ ಹಾಜರುಪಡಿಸುತ್ತೇನೆ ಅಂತಹ ವಗೇರಾ ಹೇಳಿದನು. ಆಗ ಸಿಪಿಐ ಸಾಹೇಬರು ನಾವು ಮತ್ತು ಆರೋಪಿ ಅಬ್ದುಲ್ ಮೊರಡ್ಗಿ ಮತ್ತು ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಯವರು ಮತ್ತು ಒಬ್ಬ ಫೋಟೋಗ್ರಾಫರ್ ಈ ಪ್ರಕಾರ ಕೂಡಿಕೊಂಡು ಸಿಪಿಐ ಸಾಹೇಬರು ಸರ್ಕಾರಿ ಜೀಪ್ ನಂಬರ್ ಸೋನ್ಸೋನೇದಲ್ಲಿ ಕೂತೆವು. ಆಗ ಆರೋಪಿ ಅಬ್ದುಲ್ ಈತನು ತಾನು ಹೇಳಿದ ಪ್ರಕಾರ ಜೀಪ್ ಚಾಲೂ ಮಾಡಿಕೊಂಡು ಹೋಗಲು ಹೇಳಿ ಕೈ ಮಾಡಿ ತೋರಿಸುತ್ತಾ ಹೇಳಿದ ಪ್ರಕಾರ ಜೀಪನ್ನು ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ ಇಂಡಿ ಠಾಣೆಯಿಂದ ಹೊರಟು ಇಂಡಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಹತ್ತಿರ ತೆಗೆದುಕೊಂಡು ಹೋದೆವು. ಅಲ್ಲಿ ಆರೋಪಿತನು ಜೀಪನ್ನು ಅಹಿರ್ಸಂಗ್ ರಸ್ತೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದ. ಮುಂದೆ ಅದೇ ಪ್ರಕಾರ ಜೀಪನ್ನು ಅಹಿರ್ಸಂಗ್ ರಸ್ತೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೊರಟಿದ್ದಾಗ ಇಂಡಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ದಿಂದ ಸುಮಾರು ಅರ್ಧ ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಇರುವ ಇಂಡಿ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಮದ್ರಸಾ ಶಾಲೆಗೆ ಹೋಗುವ ರಸ್ತೆಗೆ ಜೀಪನ್ನು ತಿರುಗಿಸಿಕೊಂಡು ಹೋಗಲು ತಿಳಿಸಿದ ಪ್ರಕಾರ ಹೋಗಿ ಅಲ್ಲಿ ಮದ್ರಸಾ ಶಾಲೆಯ ಮುಂದೆ ಜೀಪ್ ನಿಲ್ಲಿಸಿ ಹೇಳಿ ಜೀಪ್ದಲ್ಲಿಂದ ಕೆಳಗೆ ಇಳಿದು ಶಾಲೆಯಿಂದ ಪಶ್ಚಿಮ ಕಡೆಗೆ ಅಂದಾಜು 100 ಮೀಟರ್ ದೂರ ಹೋಗಿ ಅಲ್ಲಿ ಒಂದು ಸಜ್ಜೆ ಬೆಳೆ ಇದ್ದು ಬೆಳೆಯಲ್ಲಿ ಹುಡುಕಾಡುತ್ತಾ ಹೋಗಿ ಅಲ್ಲಿ ಬಿದ್ದ ಒಂದು ಕೊಡ್ಲಿಯನ್ನು ತೋರಿಸಿದ. ಸೊ ಇಟ್ ಇಸ್ ನಾಟ್ ಮುಚ್ಚಿಟ್ಟಿದ್ದಲ್ಲ,
ಸಜ್ಜೆ ಬೆಳೆಯಲ್ಲಿ ಓಪನ್ ಪ್ಲೇಸ್ ಅಂತ we can consider as open place.
Lords, it is not where it has been kept in hidden, it is thrown. It is a place which is accessible, open and accessible to one and all, Lords. It is not some, and it is just about 100 meters away from the place of incident.
Playground, in a road, it's a different aspect. ಸಜ್ಜೆ ಬೆಳೆ ಮಿಡ್ಲಿಂದ ಹುಡುಕಿ ಕೊಡ್ತಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಎಲ್ರಿಗೂ access ಹೆಂಗೆ?
Kindly see, Lords. Why would I search, Lords? Kindly see what they have written. ಜೀಪ್ ದಲ್ಲಿಂದ ಕೆಳಗೆ ಇಳಿದು ಶಾಲೆಯಿಂದ ಪಶ್ಚಿಮಕ್ಕೆ ಕಡೆ ಅಂದಾಜು 100 ಮೀಟರ್ ದೂರಕ್ಕೆ ಹೋಗಿ ಅಲ್ಲಿ ಸಜ್ಜೆ ಬೆಳೆ ಇದ್ದು ಬೆಳೆಯಲ್ಲಿ ಹುಡುಕಾಡುತ್ತಾ ಹೋಗಿ. ಐ ಸರ್ಚ್ ದೇರ್, ಮಿಲಾಟ್ಸ್.
Only one question.
Mallards.
Now, ಸಜ್ಜೆ ಬೆಳೆ ಅಂತ ಹೇಳ್ತಾನೆ.
ಹೌದು.
Date of incident is
24/9.
24/9/2000.
Yes, Mallards. 22/11 he arrested.
3 ತಿಂಗಳಾದ್ಮೇಲೆ.
2 months.
2 months.
2 months.
ಅದಕ್ಕೆ ಸಜ್ಜೆ ಬೆಳೆ ಅವಾಗ ಇತ್ತೋ ಇಲ್ಲ?
ಹೌದು, ಇರುತ್ತೆ ಸರ್. It's a 6-month crop.
6 months.
Yes.
ಹಂಗಿಲ್ಲ ಸ್ವಾಮಿ, my
I would
submission.
research and ನನ್ನ friend ಹೇಳ್ತಿದ್ದಾರೆ. What my answer is, Mallards. He assaulted it, he might have thrown it.
Thrown.
That's what he might have thrown, or he might have kept over there. He might have done a drama for searching that. Any of that has been found on the Bajra crop itself, my lords.
To extract section 27, that must be within special knowledge.
Definitely, my lords, on that particular land, he has kept it or thrown it, if it taken into consideration. He went over there and that was there, and same was recovered.
Whose land is that? We don't know.
It's 100 meters away from the madrasa.
Madrasa.
The very same place of incident. If at all, and for 2 months, there is bajra crop, people would not water the plants, water the crop. They will certainly find it.
ಅದಕ್ಕೆ ನೀರು ಉಣಿಸಲ್ಲ ಸರ್.
There is one aspect. Now, as far as PW2, PW5, PW6, they are being the eyewitness.
Eyewitness, yes, ma'am. When there are eyewitnesses.
Identified MO1 also, this X also. ಇದರಿಂದ ಹೊಡೆದಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ. What more is required? Is there? So now, ಮಕ್ಕಳಲ್ಲಿದ್ದಾರೆ. Where are the children? Where they?
Milots, from the, they are Milots, they are with the mother of the deceased, Milots.
Mother of the deceased.
Deceased. Since I am in custody, in fact, my mother went and approached, and she was.
Still minor?
No, they're minor. It appears that maybe the elder one might be about 17 or 18. Rest all are minor only.
Mr. SPP,
Mallards.
see, admittedly there is a dispute and she deserted the accused.
Yes.
So she was residing there
Yes.
separately and residing.
Yes.
So it's the evidence of PW2 and the others also. PW2 still categorically stated that ನನ್ನನ್ನು ಬಿಟ್ಟು ಯಾಕೆ ಇಲ್ಲಿ ಇರ್ತೀಯಾ ಅಂತ ಜಗಳ ತೆಗೆದ ಮತ್ತೆ ಹೊಡೆದ. So as per PM report is single blow.
Yes, ma'am. Yes, ma'am.
She succumbed to the injury after 1 day.
Yes.
What is ground to section for this one?
Mallards, my submission would be
Exception to.
the intention, with an intention, he entered the madrasa with an deadly weapon, that is an axe. Then what does it shows me? What was his intention?
From that Mahazar, it says the axe was taken from the kitchen.
No, Mallards.
ಇದರಲ್ಲಿ
He came along with an axe. Means.
That means what we are saying, that in your, that exhibit P4, Shalaya Adige Konege Hogi, means maybe there something has happened. So he goes and gets that and comes. So suppose he has come with that. Exhibit P4, Shalaya Adige Konege Hogi, he gets that. So suppose he has brought it with him, that intention becomes firmer. But if it is available somewhere there in the vicinity,
all the witnesses who are said to be the eyewitness to the incident, my lords, all have stated that he came with an axe. 5 and 6 and PW1, PW2.
Thereafter they came to the spot. As per the 5 and 6, their evidence is very clear. Matte bandevu now already. PW5. ಅಡಿಗೆ ಕೋಣೆಯಲ್ಲಿ ಜಗಳವಾಡುತ್ತಾ ಇದ್ದ ಶಬ್ದ ಕೇಳುತ್ತಿತ್ತು. ಶಬ್ದ ಕೇಳಿ ನಾನು ಅಡಿಗೆ ಕೋಣೆಗೆ ಹೋದನು. ಆರೋಪಿ ತನ್ನ page 70, come to page 70, PW5. ಮದ್ರಾಸಲ್ಲಿ 8 ಗಂಟೆಗೆ ಮದ್ರಾಸದಲ್ಲಿದ್ದಾಗ ಅಡುಗೆ ಕೋಣೆಯಲ್ಲಿ ಜಗಳವಾಡುವ ಶಬ್ದ ಕೇಳುತ್ತಿತ್ತು. ಶಬ್ದ ಕೇಳಿ ಅಡುಗೆ ಕೋಣೆಗೆ ಹೋದೆನು. ಆರೋಪಿ ತನ್ನ ಕೈಯಲ್ಲಿ ಕೊಡ್ಲಿ ಹಿಡಿದುಕೊಂಡು ಜಗಳ ತೆಗೆದು ಹೆಂಡತಿಗೆ ಬೈಯುತ್ತಿದ್ದನು ಮತ್ತು ಅದೇ ಕೊಡ್ಲಿಯಿಂದ ತಲೆಗೆ ಕೊಡಿದನು.
So it looks like that axe was there in the kitchen of the madrasa.
No. Totally kitchen dalli prashnane barala. That question doesn't arise. Yes, that question doesn't arise. In kitchen, keeping such a deadly weapon, my lords.
Handy weapon. The apex court said, if it is in a handy weapon, then 304 ಗೆ ಬರ್ಬೋದು. So ಕೊಡ್ಲಿ is to be construed as a handy weapon.
No, it's
ಚಿಕ್ಕ ಕೊಡ್ಲಿ ಅಂತ ದೊಡ್ಡ ಕೊಡ್ಲಿ ಅಲ್ಲ.
It is the 14 centimeter, my lords.
14 centimeter.
Yes, ma'am. 14 centimeter.
14 centimeter is this much.
This much handy weapon. ದೊಡ್ಡ ಕೊಡ್ಲಿ ಅಲ್ಲ, ಮರಗಟ್ಟು ಮಾಡುವಂತ ಕೊಡ್ಲಿ ಅಲ್ಲ.
ಅಲ್ಲ sir. Sir, what I meant to say, 14 centimeter is that iron size, that front size.
Yes.
Not that handle, my lords.
There's 6 inches.
More than that, my lords. That is there in the
2.5 centimeters.
Yes, 14 centimeters is about 6 inches.
Huh?
Roughly about 6 inches.
6
About
inches,
this
my
much.
lord. 6 inches.
6 inches.
That's a it is to be treated as a deadly weapon.
Half feet.
Half feet.
12 inches alva.
Yes, 12 inches is about this much.
1 foot 12 inches. 6 inches.
6 inches, that iron material which in a shell.
not made up our mind, but if at all, what you say, we were to accept fine amount as some compensation.
Yes.
How much? 1 lakh for each child?
I'll, yes, ma'am.
No, we have not made, we are just.
I'm agreeable with that
No,
proposal.
That's okay. But you see what other argument you can give to make out the case for 304, what you are saying.
Yes, I'll try.
One vital blow at a vital part with one instrument is sufficient.
Yes, ma'am. 2020 Honorable Supreme Court has said one blow can't be held as a universal rule to get the offense from 302 to.
The vital part that itself is sufficient.
Yes, Justice M.R. Shah's judgment.
So how you are going to make out a case, if at all? 307, you can't do anything. You can't do anything for 307.
It's already 9 years, so that may not. And it was before the trial court, Lords, the case was conducted by the legal aid, Lords. So, Lords may see the injured eyewitness has not been cross-examined. I'm not even relying any part of the cross-examination because there's hardly any cross-examination of some work, Lords. So, I'll have to, in fact, invariably rely on the chief of the witnesses. I'll just make some research on the injury part, Lords, or else I'm agreeable to the fine to be paid and 10 years imprisonment, Lords, that proposal. Because already for 9 years, two months he's in custody, Lords. He's not, never, I don't think so, Lords, he was even released on parole. He's been in custody all throughout. Now he has an aged mother and 3 children. I may not say because the children are with the mother of the deceased. So if he is released, maybe they may join him or with flux of time, they may not.
Person who didn't care his wife life, my lords.
Wife is different, children are different.
Is there any hope of that particular person? We are expecting that. He will take care of children's.
What is the age of the children?
The eldest one, I think, was going by probability, maybe around 15 to 17 years.
Eldest.
The eldest, because 12 years of marriage, 3 children, now about 8 years. If we add 8 years, so maybe about 15 to 17 years. I'll ascertain that aspect and make submission.
Yavaglo, insofar as third persons are concerned, it's one thing. Ganda Inti Jagla can be very violent. Can be at the heat of that moment. But intention we cannot say. Intention to kill.
addition to the fine amount imposed by the session court.
I think he'll pay. At least that should be his punishment.
Should not be plea sentence.
Yes, ma'am. Supreme Court has said in 304 cases that it should not be a flea bite.
Yes. Disappeal by the convicted accused directed against the judgment of conviction and order of sentence dated 9/1/2023 passed in SC number 90 of 2017 by the fourth additional district and session judge, hereinafter referred to as learned session judge bracket Vijaypura, wherein the learned session judge has convicted the appellant / accused for the offence punishable under section 302, 307, 504, 506 of IPC and sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 1 lakh in default of payment of fine. He shall undergo rigorous imprisonment for 1 year for the offence punishable under section 302 of IPC, further the accused sentenced to undergo rigorous imprisonment for a period of 5 years and to pay a fine of rupees 20,000 in default of payment of fine. He shall undergo simple imprisonment for 1 year for the offence punishable under section 307 of IPC. Further, the accused directed to undergo simple imprisonment for a period of 6 months in default of payment of fine. He shall undergo simple imprisonment for a period of 1 month for the offence punishable under section 504 of IPC. The accused also sentenced to undergo simple imprisonment for a period of 6 months in default of payment of fine, directed to undergo simple imprisonment for 1 month for the offence punishable under section 506 of IPC. Full stop. It is ordered that all the sentence passed against the accused shall run concurrently. Full stop. The abridged facts of the case are as follows. Case of the prosecution are as follows. The appellant accused, namely Abdul Lal Saab Mortagi, is the husband of deceased Rihanna. Full stop. There was a family dispute between Rihanna and accused. Hence, the deceased had left her husband and residing at madrasa.
No. She was residing with her parents. She was working as a cook.
Residing along with their parents and working as a cook at madrasa situated on Ashinga Road.
Ahirsang
Road near railway station of Indi town. Full stop. The PW2 complainant in this case, namely Shrimati Hussaini B, was also staying, was the co-worker with the deceased Rihanna in the said madrasa. Full stop. the full stop. On this scenario, comma, the accused repeatedly visiting the said madrasa and used to pick up a quarrel with the deceased, alleging that she was having illicit relationship with the Maulanas, that is teachers, and used teachers of the said madrasa and used to suspect her fidelity. Full stop. He used to quarrel her with frequently by visiting the said madrasa. Full stop. It is a specific case of the prosecution that on 24/9/2015, at about 8 p.m., the accused came into the kitchen of the said madrasa, situated madrasa, along with an axe that is MO1, and picked up a quarrel with the deceased Rihanna, alleging that she was having illicit affair with the Maulanas. Full stop. After saying so, he assaulted the deceased on her head with an intention to commit her murder. Full stop. The complainant was present there, tried to rescue the Rihanna. However, the accused, by abusing the complainant, also assaulted on her left hand, fingers, left knee, and attempted to cause her murder. Full stop. Please be seated, Mr.
Yes,
President.
great.
By that time, full stop, by hearing the hue and cry of the deceased and PW2, the teachers of the said madrasa, namely that madrasa, that is PW5 and 6, came and pacified the quarrel. Full stop. At that time, the accused went away by giving life threat to them. Full stop. Thereafter, the complainant, the deceased and PW2, the complainant, were shifted to Spandana Hospital, Indi. Full stop. Later, the deceased Rihanna was taken to Vijayapura District Hospital for higher treatment. Full stop. However, she succumbed to the injuries on 25/9/2015 at 7:30 p.m. Full stop. Subsequently, PW17, the investigation officer, PW17, the then PSI of the respondent police, has visited the hospital and recorded the statement / complaint by PW2 on 25/9/2015 at about 11:45 p.m. Full stop. As per exhibit 11:40 exhibit P3, and registered the FIR in crime number 288 of 2015, dated 25/9/2015, against the accused for the offence punishable under section 326, 307, 504, 506 of IPC, and started the investigation. Full stop. In the meantime, PW17 has received the information that the injured Rihanna succumbed to the injuries on 25/9/2015 in the evening hours, and as such, he has sent a requisition to the jurisdictional magistrate to invoke section 302 of IPC in crime number 288 of 2015. Full stop. Accordingly, after according the sanction from the learned magistrate, section 302 of IPC was invoked. Thereafter, the case was investigated by PW18, and on 18, full stop. On 16/11/2015, PW18 and 19, 18 and 19, full stop. In the meantime, on 16/11/2015, the accused voluntarily surrendered before the court, and PW18 took him to police custody and recorded his voluntary statement, and based on which the weapon said to have used for the commission of crime, that is MO1, has been recovered at his instance under Exhibit P4, and subsequently drawing the necessary mahazas and obtaining necessary documents from the concerned authority. So also recording the statements of the witnesses, PW19 filed the charge sheet against the accused for the aforementioned offences before the committal court. Full stop. Next part. After committal of the case before the session court, the learned session judge has framed the charges against the accused for the aforementioned offences, and the same was read over to him. However, the accused denied the charges leveled against him and claimed to be tried. Full stop. In order to prove the charges leveled against the accused, the prosecution has in total examined 19 witnesses as PW1 to 19 and marked 27 documents as Exhibit P1 to P27 and got identified 3 material objects as MO1 to 3. Full stop. On completion of the prosecution evidence, the learned session judge read over the incriminating evidence of material witness to the accused as stipulated in section 313 of CRPC. However, the accused denied the same. The defense of the accused is of absolute denial and that of false implication. Full stop. Following the assessment of oral and documentary evidence placed by the sessions court, the learned session judge convicted the appellant for the charges leveled against him and sentenced him as stated supra. Full stop. The said judgment of conviction and order of sentence is challenged in this appeal. We have heard, next part, we have heard the learned counsel Shri R.S. Lagali for appellant and Shri Siddhana, Siddhalinga Patil. Yes. Siddhalinga Patil, learned additional SPP for respondent state. Also, we have perused the records made available before us. Full stop. It is the next para. It is the primary contention of the learned counsel for the appellant that the judgment of conviction and order of sentence passed by the session court suffers from perversity and illegality. Full stop. The learned session judge has grossly erred. Like the session judge has grossly erred while convicting the appellant without duly appreciating the evidence and documents placed before him. Full stop. According to the learned counsel, the session judge convicted the appellant solely relying on the evidence of PW2, PW5 and PW6 who have claimed to be eyewitness to the incident. Full stop. However, there are material contradictions and omissions in their evidence, and same cannot be relied to prove the charges leveled against the accused. Full stop. He would contend that on perusal of evidence of PW5 and 6, it is specifically elicited in the cross-examination that upon hearing the hue and cry of other teachers and students gathered at the spot, and appellant upon at the spot, and thereafter they visited the spot, and upon seeing them, he accused fled away from the spot. Full stop. Hence, their presence in the spot cast a serious doubt. Full stop. Next, he also contends that the recovery of weapon used for the commission of crime is not proved as per settled principle of law by the Honorable Apex Court in the Inquisition of Judgments. Full stop. By enunciating the said argument, he would submit that the weapon MO1 recovered from open place accessible to general public. Full stop. He also contends that though the alleged incident took place on public road, which was thickly populated and witnessed by many of the people, the prosecution does not venture to examine any of those persons, which once again creates a doubt in the genesis of the case. Full stop. Next paragraph. Alternatively, the learned counsel submits that the entire case of the prosecution, even with the detailed analysis of the evidence, does not make out a case for the offence 302 of IPC, and at the most would fall for the offence under 304, fall under offence for under section 300 exception 4 exception 1 to section 300 of IPC, and which is punishable for the under section 304 part 1 of IPC. Full stop. According to him, the entire incident caused in a spur of moment without any such premeditation, intention or knowledge as stated in section 300 of IPC. Full stop. With these submissions, he prays to allow the appeal alternatively prays to modify the conviction and sentence imposed by the learned session judge. Full stop. Next. Refuting the above submissions, the learned SPP for the respondent state vehemently contended that the judgment challenged under this appeal neither suffers from any perversity nor illegality, since the learned session judge convicted the accused based on ample evidence available on record. Full stop. According to learned SPP, PW2 complainant and injured eyewitnesses, that is PW5 and 6, have categorically deposed about the assault made by the accused both on her and deceased. So, deceased. Full stop. The evidence of PW 2, 5 and 6 are corroborative in nature, and PW2 being the injured witness, her testimony cannot be discarded based on for the reason that there are minor contradictions. Full stop. The minor contradiction. Apart from the evidence of these three witnesses, the prosecution also relied the evidence of PW4, that is evidence of PW4 to prove the circumstance of recovery of MO1 at the instance of accused. MO1 at the instance of accused. Full stop. PW4 categorical instance of accused. Full stop. The
recovery witness PW3, sir.
Sorry, PW4 and PW3 and PW3. Full stop. Full stop. The learned SPP also contends that the evidence of evidence of PW3, PW2, 5 and 6 further corroborates with the medical evidence. That is the doctor PW9, who examined the injured PW2,
Yes,
PW2 and the wound certificate
exhibit P12.
Exhibit P12. So also the PM's report as per exhibit
P20.
P20. Full stop. P20. The doctor has clearly opined that the injuries found on the dead body could have been caused by MO1 acts. In such circumstance, MO1, full stop. It is he would contend that, it is the subtle principle of law that the minor contradictions in the evidence of material witness does not go to the root of the prosecution case. As such, their testimony cannot be discarded. Full stop. Accordingly, the learned discarded. Full stop. Accordingly, the learned session judge, after meticulously examining the evidence of the material witness, convicted the accused for the charges leveled against him, which against him in a well-reasoned judgment, which does not call for any interference. Full stop. With this submission, the learned SPP prays to dismiss the appeal. Full stop. Even on the prays to dismiss the appeal. Full stop. Next. Having heard the learned counsel for the parties and also upon comprehensive perusal of the entire evidence on record, the points that would arise for our consideration are: number one, whether the judgment under this appeal either suffers from any perversity or illegality. Number two, whether the learned session judge is justified in convicting the accused for the offense charges of the offense charge. Next one. As common narration and consideration are involved in the appeal on hand, we take the liberty to address both the above raised interrogation in the foregoing paragraphs. Next, in order to prove the homicidal death of the deceased in this case, the prosecution has predominantly relied on the evidence of Dr. PW16, who conducted the autopsy on the corpus of the deceased and issued post-mortem report as per Exhibit P20, P20, and the opinion on use of weapon as per Exhibit P21, full stop. On perusal of Exhibit P20, the cause of death opined by PW16 is that the death was due to coma as a result of head injury. This opinion of the doctor further corroborates with the contents of inquest panchanama held on the corpus of the deceased by the investigation officer PW17 as per Exhibit P1, full stop. PW1 is the witness for the same, identified and identified. Witness for the same and identified the injuries on the corpus, so also on the corpus of the deceased, full stop. Further, PW2, 6 and 7, that is the eyewitness to the incident, also deposed about the assault of the corpus. Corpus of the deceased are in ante-mortem nature, hence we are of the considered view that the prosecution has proved the homicidal death of the deceased beyond all reasonable doubt. Next para. With an ulterior motive to connect the accused to the homicidal death of the deceased, the prosecution primarily relied the evidence of PW 2, 5 and 6 on perusal of their evidence, the connect the accused to the homicidal death of the deceased. Though the prosecution has relied the evidence of prosecution has examined in total 19 witness, we feel there is no necessity of discussing the evidence of all the witness. Suffice to appreciate the evidence of the material witnesses. Full stop. The prosecution primarily relied on the evidence of PW2, 5 and 6. Full stop. On perusal of their evidence, PW2, the complainant and injured, was the co-worker of the deceased at madrasa, where the deceased was engaged in a kitchen work, engaged in cooking, has deposed that the deceased Rihanna was working as a deposed, deposed both in her complaint Exhibit P3 and before the court in her evidence, that the deceased Rihanna was working as a coolie, as a cook in madrasa along with her. The accused being her husband, on 24/9/2015 at about 8 p.m. when herself and deceased preparing food in the kitchen of the madrasa, came with an axe, came with an axe and assaulted on the head of Rihanna, questioning her why she had come there by deserting him. Full stop. When PW2 confronted him, he also assaulted on her left hand finger and left leg thumb, left leg finger, full stop.
2 fingers.
Fingers, full stop. As a result, deceased sustained severe injuries and PW2 also sustained injuries, full stop. Thereafter, PW, based on their, due to their upon hearing their hue and cry, PW 5 and 6 rushed to the spot. At that time, the accused fled away from the spot along with the weapon, that is MO1, full stop. Thereafter, the deceased and PW2 were shifted to hospital at initially at Spandana Hospital, Indi, and the PW2 treated in the said hospital. However, for higher treatment, the deceased shifted to Government Hospital, Vijayapura, Government Hospital, Vijayapura, full stop. Vijayapura. This consistent version of PW2, both in the complaint and before the court, inner evidence, complaint and inner evidence before the court, is corroborated to the medical evidence, that is the evidence of PW9, the doctor who examined the PW2 and issued wound certificate as per Exhibit P12. Further, the postmortem report also discloses injury on the head of the deceased, full stop. PW1 lodged the complaint in the hospital before PW17, PW17, full stop. In such circumstance, the evidence of PW2 is unblemished and believable one, full stop. Further, coming to the evidence of PW5 and 6, who are the teachers of madrasa, where the deceased was engaged in where the deceased was employed, they both of them categorically stated that on the date of incident, the accused came there and picked up a quarrel with the deceased Rihanna and assaulted on her head on her head, full stop. He, according to them, he also assaulted PW2 with the same axe, full stop. All these witnesses, though cross-examined by the defense at length, nothing worthwhile has been elicited to discard their testimony, full stop. Moreover, all these witnesses also identified MO1 weapon used for the commission of crime, that is axe, full stop. The full stop. On careful perusal of the evidence of PW4 and the investigation officer, the prosecution also proved the recovery of MO1 axe under Exhibit P4 recovery mahazar, full stop. PW3, the witness for the same has supported the case of prosecution, full stop. The prosecution, full stop. Prosecution, full stop. Further, the doctor who conducted autopsy on the corpus of the deceased has also given the opinion on use of weapon MO1 as per Exhibit P 22 as per Exhibit P22, that Exhibit P22, full stop. As such, Exhibit P22. Further, the prosecution also placed the FSL report alva, FSL report as per Exhibit P27, Exhibit P27, wherein the opinion issued by the scientific officer reveals that the presence of bloodstains detached on on X MO1, and the same is stained with the human blood belongs to O
Exhibit
group.
P20,
Exhibit P
20, not 22.
27 FSL report.
ಅಲ್ಲ ಅಲ್ಲ sir. ಮೊದ್ಲಿಂದ
ಮೊದಲಿದ್ದ Exhibit P20.
22 ಅಲ್ಲ 20.
P20 ಅಂತ ಮಾಡ್ಕೊಡಿ.
Please.
Opinion P20.
Yes, ma'am.
Now Exhibit P27 ಆಯ್ತಲ್ಲ. Detached on X MO1 and the same is stained with the human blood belongs to O group. O blood group. O blood group. Full stop. In such circumstance, the prosecution has placed sufficient material to prove that on the date of incident, the accused visited the alleged spot of incident and assaulted the and quarreled with the deceased and quarreled with the deceased and assaulted on her with the MO1 acts. So also to PW2 with the same acts. Full shot. Same acts. The evidence of these three witnesses along with these three witnesses coupled with the medical evidence and the scientific scientific evidence, we are of the considered view that the learned session judge has rightly appreciated the evidence of the material witnesses and of the material witness that the accused is the perpetrator of the crime. Full stop. Next paragraph. The alternative contention raised by the learned counsel for the accused that the act committed by the accused squarely falls within the ambit of section 300, exception 4 of IPC, which is punishable under section 304, part 1 of IPC. Full stop. IPC is concerned, on careful perusal of the evidence of PW2, 5 and 6, the motive behind purporting the act as contended by accused in his defense is that the accused was suspecting the fidelity of the deceased, that she was having illicit affair with the Maulanas at madrasa and being enraged with the said act, enraged with the same, he went to madrasa and inquired the deceased. At that time, in a sudden row erupted, leading to the accused assaulting the deceased, and further to PW2. Full stop. The next part. The evidence of PW2 on careful perusal of the evidence of PW2, the same fortifies that the appellant neither took undue advantage nor acted in a cruel / unusual manner at the time of incident or the post commission of the crime. Full stop. Moreover, the evidence of PW 5 and 6 reveals that the accused inquired the deceased for the reason she deserted him and residing in the madrasa, and quarrel took place between them on that issue. Full stop. In such circumstance, the death of the deceased was caused, such circumstance, it can be construed that the death of the deceased was caused due to a sudden fight without premeditative motive. Full stop. Honorable Apex Court in the case of Ranbir Singh. Ranbir Singh. Yes. In the case of Ranbir Singh, the appellant, Ranbir versus State of NCT, Delhi report in 2019, volume 6, SCC 122, held that in a sudden fight, in the absence of premeditated motive, when an act is committed, in a heat of passion, should the offender not to take undue advantage or in a cruel unusual manner, the conviction can be converted from section 302 to section 304 part 1 or part 2 of IPC. ಇದರಲ್ಲಿ paragraph number 18 ಅನ್ನು ಎಲ್ಲವನ್ನು ಹಾಕೊಳ್ಳಿ, paragraph 18 ಹಾಕೊಳ್ಳಿ, ಎಲ್ಲವನ್ನು having regard the evidence of record so and so ಅದನ್ನ next. Further the honorable apex court in the case of Surendra Kumar versus Union of India, Union Territory of Chandigarh, reported in 1989, volume 2 SCC 217, held that merely because 3 injuries were inflicted on the deceased by the accused is insufficient to establish that the accused acted in a cruel manner. Full stop. Where on a sudden quarrel, a person in the heat of movement picks up a handy weapon, thereby causing injuries, one of which proves fatal, he would be entitled to the benefit as stipulated in exception 4 under section 300 of IPC. Full stop. The number of wounds inflicted during the altercation is not decisive factor. Full stop. Then you put it. Factor. Hence, considering the overall evidence of fact and circumstance of the case, the incident caused without premeditative motive, that is in a sudden scuffle between the appellant and the deceased in the heat of passion. Besides, the appellant neither took undue advantage nor acted in a cruel or unusual manner. Full stop. Unusual manner. Though it is vehemently contended by the learned SPP that the evidence of PW2 clearly depicts that the accused inflicted repeated blows on the deceased, and also he has caused injuries on PW, and also he has assaulted to PW2 in such circumstance, it has to be construed that the accused has a clear intention and motive to commit the murder of deceased. However, as per the law laid down in the above case, in the Surendra Kumar case, the Honorable Apex Court has clearly clarified the position that the repeated blow, the number of wounds inflicted during the altercation is not a decisive factor. Full stop. Further, the accused has convicted. Further, the learned session judge has convicted the accused for the offence 307 of IPC. Full stop. 307 of IPC. Full stop. As discussed supra, on considering discussed supra on perusal of the evidence of the evidence of PW 2, 5 and 6, we are concurrent with the view taken by the learned session judge in respect of the conviction held against the accused for the offense punishable under section 307, 504 and 506 of IPC, except for the offense punishable under section 302 of IPC, which falls within the ambit of section 300 exception 4, which is punishable under section 304 part 1 of IPC, full stop. 1 of IPC, full stop. For the foregoing reasons, in that view, the appeal partially succeeds. The accused is convicted for the offense under exception 4 to section 300 of IPC and sentenced for the offense punishable under section 304 part 1 of IPC instead section 302 of IPC, full stop. So far the question of sentence for the offense punishable under section 304 part 1 of IPC is concerned, it is submitted by the learned counsel for the appellant that the accused is currently under incarceration of 9 years, 2 months. Hence, in our considered view, the said sentence would suffice for the offense punishable under section 304 part 1 of IPC by imposing reasonable fine. However, the conviction imposed by the trial court for the offense punishable under section 307, 504 and 506 of IPC deserves to be kept intact, full stop. Further, full stop. The reasons discussed supra, the conviction against for the offense punishable under section 300 IPC is liable to be set aside by confirming the conviction for the rest of the offences, full stop. In view of the foregoing reasons, we answer point number 1 in the negative, and point number 2 partly affirmative, and proceed to pass the following order. Criminal appeal is allowed. Number 2, the judgment of conviction and order of sentence dated 9/1/2023 passed in SC number 90 of 2017 by the 4th additional district and session judge, Vijayapura is modified. Accused appellant is convicted for the offense punishable under section under exception 4 to section 300 of IPC instead of section 302 of IPC. Accordingly, he is sentenced for the offense punishable under section 304 part 1 of IPC, full stop. The accused is sentenced for a period which he has already undergone, that is 9 years, 2 months, and additionally, he shall pay a fine of rupees 3 lakhs. 3 lakhs. 3 lakhs
to each.
How is he placed, Mr. Lagali? In financially, how is he?
Not placed well. Maybe a small piece of land, that's about it.
My lords,
Yes.
definitely is going to
Rest
marry
of the
next.
sentence, rest of the sentence and fine amount will not disturb. Only as per the 302 what I imposed by the session court, it's 1 lakh rupees.
Yes.
Now, we shall pay fine of 3 lakh. We'll impose 3 lakh.
Yes.
Instead of 1 lakh, 3 lakh.
Each.
3 lakh ಅಷ್ಟೇ.
Each
For the each
children.
Huh?
Each children.
Each children ಎಲ್ಲಿ
Definitely is going to marry in, because he's a 44, 45 man. Their children will be thrown out, definitely, it's a damn sure.
Like if that is the case, Mr. SPP, even after another 2 to 3 years, he'll come out and he'll back. If he had such intention. If the will be 3 lakhs, any fine amount deposited, Mr. Lim? No, yes. Full show. In default, for the offense, okay, for the offense punishable under section 304, part 1 of IPC, and in default of payment of fine, he shall undergo simple imprisonment for a period of 2 years. For a period of 2 years, full show. If the fine amount, full show. If the fine amount is deposited by the accused, the learned session judge is directed to disburse the same to the children of the deceased equally as compensation stipulated under section 357A, 357(1) of CRPC on due identification. Next part, the sentence, next part. The sentence imposed by the session court for the offense punishable under section 307, 504, 506 of IPC against the accused are kept intact. The next, the accused shall be released on payment of fine amount as above or undergoing the default sentence or undergo default sentence. Next, the victim compensation granted by the learned session judge. Nodi, victim compensation granted by the learned session judge under section 357A ena kottiddaralva. 357A.
Yes.
Eh?
They have directed
357A subclause 5 of CRPC
they have directed the
is also kept intact.
Yes.
Is also kept intact. Adu ಏನು ಅವರು ಕೊಡ್ತಾ ಹೇಳಿದ್ದಾರೆ ಅದು ಕೊಡ್ಲಿ ಅವರು kept intact. Next. Out of the fine amount imposed by the learned session court session judge for the offense punishable under section 307, 504, 506, rupees 20,000 shall be paid to PW2 on due identification. Next, registry is directed. Bail bond registry is directed to send back the records along with the copy of this judgment before the trial to the trial court for necessary action. Appeal is partly allowed. First, criminal appeal is partly allowed. First, criminal appeal so and so partly allowed anta matte idella baru. Criminal appeal partly allowed anta first ಗೆ ಹಾಕೊಳ್ಳಿ.
My lord, is there in second of 2:30, please,
I'm sitting in bench.
please.
ನಿಮ್ಗೆ ಇವತ್ತು ಮಾತ್ರ ಅರ್ಧ ದಿನ ರಜಾ.
Yes, madam. Yes, madam. That's what I'm asking. Otherwise, I'm ready for another 2 appeals.
ಅಲ್ಲಿ ಬಿಡಲ್ಲ.
And no, sir. ಮೂರು ಬ್ಲೋತ್ ಇಂಟೆನ್ಷನ್ ಇಟ್ಕೊಂಡ್ರ ಈಗ ನಿಮಗೆ ಬರೆದಿಟ್ಟಿನ ದೇರ್ ಇಸ್ ನೋ ಕ್ರಾಸ್ ಹೇಳ್ಬೇಕಂದ್ರೆ ಈಗ ಲಗಳಿ ಇಲ್ಲಿ ಬಿಟ್ಟು
ಒಳಗಿಟ್ಟು ಅರಿವಿಲಿ ನಡೆಸಿದ್ರು
ಇಲ್ಲ ಒಂದು ಇವತ್ತಿಂದ
ಬರಲ್ಲ ಅವ್ರು.
ಸಾಕಾಗಿದ್ದು ಕೇಳ್ತಾ ಇರೋದ ಈಗ ಒಮ್ಮೆ ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ವಿಡಿಯೋ ಆನ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಧನಂಜಯ್ ಒಂದಲ್ಲ ಫೈನ್ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ ತಡ್ರಿ. ಶ್ರೇಯ ಹೇಳಮ್ಮ, ಹೇಳಮ್ಮ ಶ್ರೇಯ. ಸರಿ 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 ಓಕೆ. ಇದು ಮೇಡಮ್ ವಿಜಯಲಕ್ಷ್ಮಿ ಮೇಡಮ್,
ಸರ್
ಇದು ನಮ್ಮ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ ಈ ಕಡೆಯಿಂದ, ನಿಮ್ಮ ಸಾಹೇಬ್ರಲ್ಲಿ?
ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಓಕೆ ಮೇಡಮ್ ಓಕೆ.
ಬರ್ತಾ ಇದ್ದಾರೆ.
ಸ್ವಲ್ಪ ವಾಯ್ಸ್ ಕಡಿಮೆ ಆಗ್ತದೆ.
ವಾಯ್ಸ್ ಕ್ಲಾರಿಟಿ ಇದೆ ಸರ್. ನಿಮ್ ಕಡೆ ಕೇಳ್ತಾ ಇರೋದಾ ಸರ್?
ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಕೇಳ್ತಿದೆ ಸರ್.
ಸರಿ ಸರ್, ವಾಲ್ಯೂಮ್ ಜಾಸ್ತಿ ಮಾಡ್ತೀನಿ.
ನೋಡ್ತೀನಿ. ಇದು ಸ್ವಲ್ಪ ಇದು ವ್ಯಾಲಿ ಏನಪ್ಪ ಇದು?
ಈಗ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಅವ್ರ ಮ್ಯೂಟ್ ಮಾಡ್ತೀನಿ.
ಮೇಡಮ್ ರವಿ ವರ್ಮ
ಜಗದೀಶ್ ಸರ್ ಆಡಿಬಲ್ ಇರೋದಾ ಸರ್?
ಆಡಿಬಲ್ ಇದೆ, ಆಡಿಬಲ್ ಇದೆ.
ಹೇಳಿ.
ನಮಸ್ತೆ ಸರ್.
ನಮಸ್ತೆ ಮಾ, ನಮಸ್ತೆ ನಮಸ್ತೆ.
ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಈ ಬ್ಯಾಚ್ನಲ್ಲಿ ಅವರು ಮತ್ತೆ ಪಾಟೀಲ್ ಮತ್ತೆ ಇವರು ಕವಿತಾ ಬಂದು ಅವ್ರ 3 ಜನ.
ಸರ್ ಇದು ಸೈಟೇಷನ್ ಅಲ್ಲಿ ಕಳ್ಸಿದ್ರಿ ಸರ್.
ಅಲ್ಲಿ
ಸರ್ ಅಲ್ಲಿ ಹೆಂಗೆ ಕಳ್ಸಿದ್ರಿ ನೀವು? ಅಲ್ಲಿ ಯಾರಿಗಾದ್ರೂ ಪರ್ಸನಲ್ ಕೊಡ್ತಾರೆ ಹೆಂಗೆ? ರಂಜಿತ್ ಸರ್ ಅವರು ರವಿ ಬಿ ಪಾಟೀಲ್ ಸರ್ ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ರು, ಬಂದಿದ್ದೇನಾ ಸರ್?
ಮೇಡಮ್ ಬಂದಿದೆ, ಈಗ ಬಂದಿದೆ.
ಇಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್ ಈಗ.
ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಖುದ್ದಾರ್ ಸಾಹೇಬ್ರದ್ದು ಈ ಸಾಹೇಬ್ರದ್ದು ಡಿಬಿ ಇದೆ ಸರ್. ರೆಗ್ಯುಲರ್ ಮುಗಿತ್ ಸರ್.
ನಮಸ್ತೆ.
ನಮಸ್ತೆ ನಮಸ್ತೆ.
Given serial number 1 C Jagdish.
Appellant.
May it please my lord, sir. Index.
Yeah, but handle that index. My lords, I'll just invite my lord's attention to one letter which is on record of the Directorate of Civil Rights Enforcement. I pointed out, my lords, from the writ appeal paper book on the last occasion with referring to the TRESL report, which is at Z7, which is, my lords, the report of the CRESL, annexure Z10, page 472. Page 472. Volume 2 of the writ appeal paper book. 472 is the report. With referring to that, I pointed out that it was initiated on a complaint made by ಬೇಡಜಂಗಮ ಸುಳ್ಳು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ವಿರೋಧಿ ಹೋರಾಟ ಸಮಿತಿ ಮತ್ತು ರಾಜ್ಕುಮಾರ್ ಮೂಲ ಮಹಾಪ್ರದರ್ಶಕ ಹಾಗೂ ಸಂಘದ ಇತರ ಪದಾಧಿಕಾರಿಗಳು ಸಹಿ ಮಾಡಿರುವ ಅಂತ. My lords, I got a complete file given by the DCRA under RTI Act. In that, my lords, at page in that file of the TRE cell, there is a letter, a complaint addressed, a similar complaint addressed to the Jilla Police Varishta Adhikarigalu anta. That is at page 104 of the DRG, the Directorate of Civil Rights Enforcement file. It is not there before, my lords. In fact, I also got this document just today only. There is one, my lords, a complaint made by Karnataka Rajya Dalita Sangarsha Samiti, which is the division petitioner before the Deputy Commissioner, and which is also an appellant before my lords in the second of the appeals listed. That letter was addressed, that complaint was addressed, my lords. That is dated 18/3/2020 to the Manya Jilla Police Varistadhikarigalu Bidara. That is Karnataka Rajya Dalita Sangarsha Samiti, registered. ಅದರ ಕೆಳಗೆ ದಲಿತ ವಿದ್ಯಾರ್ಥಿ ಒಕ್ಕೂಟ. Then, my lords, this is a complaint also signed by the very same persons, Umesh Kumar Swaraldikar, Rajkumar Bharati, etc. What I would like to point out from the file of the DCRE is that, in addition to complaint of the ಬೇಡಜಂಗಮ ಸುಳ್ಳು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ವಿರೋಧಿ ಹೋರಾಟ ಸಮಿತಿ, there was also a complaint to the DCRE made by the Karnataka Rajya Dalita Sangarsha Samiti itself. It is available in the DCRE records, but a separate copy of this, I will have it filed for my lord. Identically worded. So what I would like to submit is, my lords, it is the Rajya Dalit Sangharsh Samiti and its office bearers under the headline of another banner as Beda Jangama, Sulu Jati Virodha Patra, etc., which invoked the jurisdiction of the CRE cell. One of the questions that would arise in the light of this is whether it is open to the state or to the complainant who made a complaint to the very same police outfit to contend before my lords today that TCRE had no jurisdiction to investigate. Now, my lords, this is I'll take my lords through one of seriatim. What are the issues that arise? I have on the last occasion argued, my lords, that writ appeal 200053 of 2024, that is the first appeal filed by the state, it is not maintainable because on the day they preferred the appeal. This appeal was filed on, my lords, on 18th November 2013. If my lords would see the title sheet in the writ appeal 200053, which is the first of the appeals listed, the date of filing of that writ appeal is 16/11/2013 or 18/11/2013. Long anterior to that, on 2nd September 2023, it is filed on 18/11/2023, before which the Karnataka government Karnataka Conduct of Government Litigation Act, which had come into force on 2nd September 2023. Under this act, my lords, the my lords are having a copy of that act. In fact, when my lords were sitting at Bangalore, that act was taken out and kept along with the paper book.
Which act?
That is known as Karnataka Conduct of Government Litigation Act 2023. It is a blue color book, my lords, or green color book, as I don't know. It is
Karnataka
Conduct of Government Litigation Act 2023. My lord Huddar may be having a wrong book, my lords. That may not be the correct book. Adu caste certificate kottidare book tamge anta kanuತ್ತೆ. The book is Karnataka Conduct of Government Litigation Act 2023 Act.
Yes.
That had come into force, my lords, on 2nd September 2023. That is discernible, my lords. From today, one additional list of authorities had been filed. In that list compilation, at page 61 is the notification.
Yes.
That notification says, Karnataka Rajya Sarkari Rajya Vyajya Nirvahane Adhiniyama 2023 ಪ್ರಕರಣದ 1ನೇ ಪ್ರಕರಣ 2ನೇ ಉಪ ಪ್ರಕರಣದಡಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರವು ಈ ಮೂಲಕ ಸದರಿ ಅಧಿನಿಯಮದ ಎಲ್ಲಾ ಉಪಬಂಧಗಳು ದಿನಾಂಕ 2/9/2023 ಜಾರಿಗೆ ಬರುತ್ತದೆ ಎಂದು ಗೊತ್ತುಪಡಿಸಿರುತ್ತದೆ. So this has come into force before filing of the present appeal. Now, my lord, section 4 of this act, it stipulates yes, government permission required for institution of cases, subject to general or special orders made by the government in this behalf. No case on behalf of the government or any of its officers shall be instituted in a court against any person or authority without the sanction of the government granted in accordance with the provisions of this act. Section 5, my lords, it lays down procedure for institution. That lays down a detailed procedure how the permission of the government has to be obtained. Then, my lords, section 29 appeal, review and revision, appeal by government. That is what the title of section 29. Here again, it says, where orders are issued authorizing filing of an appeal, review or revision, the litigation conducting officer shall approach the concerned law officer and give him necessary instructions, etc. Then, my lord, section 38. Writ appeals. The provision of chapter 5 shall apply mutatis mutandis to appeals against orders in writ proceedings. That is, my lord's permission as under section 29 and also section 4 and 5 will have to be obtained, and it has to be stated. Here in the instant case, what has happened is there is no averment that permission of the government has been obtained or issued under the provisions of the Karnataka Conduct of Government Litigation Act. And in all interlocutory applications accompanying the writ appeal, affidavit has been signed by the Deputy Commissioner, whose order is under challenge here. My respectful submission is, my lords, whatever be the position prior to 2/9/2023, the writ appeal filed in November 2023 without complying with the provisions of the Karnataka Conduct of Government Litigation Act are not maintainable. There is no whisper in the entire writ appeal that permissions as required under this act have been obtained. If no permission as required under this act has been obtained, then the appeal filed on behalf of the state would be incompetent. Then, my lords, the third appellant in the government's writ appeal is the Deputy Commissioner. It is the order of the Deputy Commissioner which is the subject matter, which was the subject matter of the challenge before the learned single judge, which my lords would get. The prayer in the writ petition is at page 111, volume 1. Yes. Prayer, my lords, in the writ petition was issue a writ of certiorari, thereby quash the impugned order dated 3/4/2023 in file number so and so as at annexure Z13 passed by the fifth respondent. Z13 is at page 582, which is the order of the Deputy Commissioner. Yes. Second prayer, there is only consequential. That is to say, if the Deputy Commissioner's order is set aside, consequence with the caste certificate issued to me will be confirmed. Now the question is, my lords, state definitely has got a right to appeal. I am not questioning the power of the state to file. But other than the state, a quasi-judicial authority who is an officer of the government, he has no locus to file an appeal against the order in the writ petition, contending that his own order is correct. That power is vested only in the government, not in any subordinate officer. That is the law declared, my lords, by the Supreme Court in Mohtesham Muhammad Ismail. That is, my lords, 2007, 8 SCC 254. I had requested the court officer to take out the book, my lords, because this one has not been filed. But the judgment of the Madras High Court only has been produced here, unfortunately, today. 2007, 8 SCC 254. We'll get it. Yes, my lords. In that judgment, my lords, paragraph 16. May I just read out the text of paragraph 16, my lords, by the time my lords get the book? Paragraph 16 at page 262, my lords.
No, now this argument is as regards writ appeal
Writ appeal 20053. That is the first writ appeal filed by state and 7 of its officers.
Yes.
Now, my lords, totally there are 8 appellants there. First appellant is the state, and this appeal on behalf of the state should fail for non-compliance with the mandatory provisions of the Karnataka Conduct of Government Litigation Act 2003. Then, my lords, appellant number 3 is the Deputy Commissioner, who affirms all the writ appeal papers on behalf of all the appellants.
Yes.
Now, my lords, para 16 of this judgment, an adjudicating authority exercises a quasi-judicial power and discharges judicial functions when its order has been set aside by the board. Ordinarily, in the absence of any power to prefer an appeal, it could not do so. The reasoning of the High Court that he had general power, in our opinion, is fallacious. For the purpose of exercising the functions of the central government, the officer concerned must be specifically authorized. Here, that requirement has been stipulated in the 2023 Act. Only when an officer is so specifically authorized, he can act on behalf of the central government and not otherwise. Only because an officer has been appointed for the purpose of acting in terms of the provisions of the Act, the same would not by itself entitle an officer to discharge all or any of the functions of the state government. Even ordinarily, a quasi-judicial authority cannot prefer an appeal being aggrieved by and dissatisfied with the judgment of the appellate authority, whereby or wherein its judgment has been set aside. An adjudicating authority, although an officer of the central government, should act as an impartial tribunal. An adjudicating authority, therefore, in the absence of any power conferred upon it in this behalf by the central government, could not prefer any appeal against the order passed by the appellate board. Next, my lords, paragraph, they extract the judgment of the Madras High Court, Rama Arangannal, and they approve the Madras High Court judgment. That Madras High Court judgment is at page 1 of today's compilation, at page 1 of the today's compilation, which I have filed. I am citing the judgment of Madras High Court because Supreme Court approved the judgment of Madras High Court while reversing the division bench judgment of our High Court. My lords would take that first judgment there, my lords, Director of Enforcement, Madras versus Rama Arangannal. Para 3 at page 2, right-hand column, my lords. Fifth line. Therefore, the Director of Enforcement cannot in any sense be equated with or treated as the Government of India. Further, it is significant to note that even the amendment petition has been filed only by the Director of Enforcement and not by the Government of India. It would have been a different matter if the Government of India had filed a petition stating that the appeal has been filed at their instructions, but it has been filed by mistake or inadvertence in the name of the Director of Enforcement. And therefore, Government of India may be allowed to be shown as the appellant. Having regard to the fact that the government has not so far come into the picture, the petition for amendment filed by the original appellant, Director of Enforcement, for a change in the name of the appellant from Director to the government represented by the Director cannot be allowed. Hence, the said petition has to be dismissed, and it is dismissed accordingly. On the question as to the maintainability of the appeal, it is seen that explanation to Section 54 of the Foreign Exchange Management Act, etc. My lords may skip those two sentences. Therefore, only the central government can prosecute an appeal before the appellate board. In this case, appeal has been filed by the Director of Enforcement, who is the initial authority who passed the adjudication order against the respondent, and whose order has been satisfied by the appellate board on an appeal filed by them. Therefore, the Director of Enforcement cannot be said to be aggrieved by the order of the appellate board merely because its order of adjudication has been set aside by the appellate court. If that were to be possible, every subordinate tribunal can file an appeal against the order of the appellate tribunal, reversing its decision to a further appellate forum. The Director of Enforcement cannot be treated as an aggrieved party, for while passing the order of adjudication, he has acted only as a quasi-judicial tribunal, and such a quasi-judicial tribunal cannot have a grievance when its order is set aside by higher appellate forum. If he entertains a grievance where the appellate forum satisfies its order, then he should have taken to have had a bias in the dispute which has been adjudicated by him. The moment Deputy Commissioner files a writ appeal against the order of the learned single judge which has set aside his order, bias is presumed. Therefore, it will be against the principle of natural justice if we assume that the Director of Enforcement is a quasi-judicial tribunal adjudicating a matter between the government and the person sought to be proceeded against for violation of the provisions of the Act, had an interest, personal or otherwise, in the matter which was the subject matter of the dispute which he adjudicated. It would have been a different matter if the statute authorized the Enforcement Directorate, Director of Enforcement, to file an appeal. But admittedly in this case, the Director of Enforcement has not been statutorily authorized to file an appeal against the order of the appellate board at the instance of the Government of India or otherwise. If the quasi-judicial tribunal is expected to question the orders of the appellate bodies, etc., then last line there, such a statutory provision is necessary for the reasons aforesaid, or otherwise it will lead to the inevitable conclusion that the initial authority had an interest in the dispute before it, and therefore it considered itself aggrieved when its judgment was reversed by an appellate forum. In view of this, the who is the appellant in this case cannot be said to be an aggrieved person. Next paragraph about second half of this. In this case, that is paragraph 5. In this case, apart from the fact that cause title in the memorandum grounds of appeal shows only the director, no material has been placed before the court, even after the question of maintainability has been raised, to convince the court that the central government actually decided to appeal against the order of the appellate board and instructed the Director of Enforcement to file the appeal on their behalf. I am inclined to hold that appeal filed by the Director of Enforcement against the order of the appellate board cannot be maintained. The question is this, my lords. If the state government had authorized, it is justifiable for the reason that it may involve a policy matter. For example, one question of law has been raised in the writ appeal, say by this, saying that the remand should not have been to the District Caste Verification Committee, but it should have been only to the Deputy Commissioner. That is the fundamental ground raised in the state's appeal, which stand state alone could have taken. Otherwise, it would be without jurisdiction. The appeal filed by the Deputy Commissioner only for the reason that the learned single judge has set aside his order and not remanded the matter to him, but has remanded the matter to the DCVC. Such an appeal would not be maintainable impliedly by virtue of these two judgments, the Madras High Court judgment and the Supreme Court judgment affirming it. Even otherwise, my lord, what is the personal interest of a quasi-judicial authority to come in appeal and say, after all, the learned single judge has not, for all times to come, sanctified my caste certificate. All that he has said is that validity of the caste certificate should be judged by the District Caste Verification Committee. Therefore, I am remanding the matter, I am sending the matter to the District Caste Verification. Only grievance that the state can have is that it should, suppose it is of the view that DCVC is not competent, it can be only to the Deputy Commissioner. But Deputy Commissioner cannot say, it should come back to me only, so that I can again finish him in accordance with law. Then, my lords, the second question is, the my lords would see the array of appellants in the government's appeal. Second appellant is the Commissioner, Department of Social Welfare. No order of his has been set aside. No doubt he was a respondent in the writ petition. But the only course open to the deputy commissioner or the state, as the case may be, was to have said, it is a formal party, make it a respondent, and request the court, if they so desire, to dispense with notice. The fourth appellant is Assistant Commissioner Bidar. The only finding against the Assistant Commissioner Bidar in the writ petition is that since his report is based on an inquiry conducted without notice to the petitioner, that material could not have been relied upon. He cannot be aggrieved by that. Fifth is Tahsildar Bidar. Learned single judge has only confirmed his caste certificate issued by him. He was a necessary party in the writ petition because the caste certificate issued by him had been reversed by the deputy commissioner, and I had filed a writ petition questioning the order of the deputy commissioner and seeking restoration of the caste certificate issued by the Tahsildar. If the learned single judge has upheld the caste certificate issued by Tahsildar, I don't know how Tahsildar can be aggrieved unless he says that I was wrong in issuing the caste certificate. Then, sixth is the district social welfare officer, sixth appellant. No order of district social welfare officer has been set aside. Seventh is Taluk social welfare officer. I had to make him a party because Taluk social welfare officer's report was also one of the materials considered by the Tahsildar in issuing me the caste certificate. And Assistant Commissioner in his report had said the social welfare officer, without conducting any spot inquiry, he has submitted a report. Then is Additional Director General of Police. What has been done against him? His report is in my favor. That report is not set aside, nor that report was challenged either by the complainant or by the state. Therefore, my lords, my respectful submission is, it is grievance of a quasi-judicial authority, namely the deputy commissioner, that is being agitated in the appeal filed ostensibly by 8 persons, but in effect only by 1 person, because no authorization from the state as required under the 2023 Act has been produced, nor has been awarded. Therefore, my respectful submission is, this appeal by the state and its officers is liable to be dismissed as not maintainable, because as appellants, ADGP and the Tahsildar or the Taluk social welfare officer cannot come and argue before my lords. My reports or my order is wrong. Only order set aside is the order of the deputy commissioner. No, my lord, the second set of appeal before my lords is the appeal by Karnataka Rajya Dalita Sangharsha Samiti, which was the complainant or appellant or revisionist, as my lords would be pleased to describe them. That is the Karnataka Rajya Dalita Sangharsha. My respectful submission is, in fact, my lords, on the last occasion, I had read out to my lords annexure Y, the so-called appeal, an annexure Y, that is my lords, there are two documents marked as annexure Y. Y at page 278. I have already read out to my lords this document. I don't want to read it again and waste the time of the court. Annexure by page 278 is the appeal filed by Karnataka Rajya Dalita Sangharsha Samiti before the Assistant Commissioner to have the caste certificate issued to be cancelled. The entire reading of this document dated 23/10/2029 does not disclose as to any right of this Dalita Sangharsha Samiti being infringed by issue of caste certificate to me or by the Tahsildar passing an order directing issuance of caste certificate to me. Secondly, it was also not an objector before the Tahsildar, because after the matter was remanded to the Tahsildar by order annexure U at page 255 by this Honorable Court, Tahsildar conducted an inquiry. Rajya Dalita Sangharsha Samiti was not an objector before the Tahsildar. It filed directly an appeal. And I have already pointed out that it was barred by limitation. By reading the contents of this entire annexure Y, it cannot be said to be an aggrieved party or aggrieved person, because section 4 capital B specifically confers right of appeal only to a person aggrieved by any order of the Tahsildar granting caste certificate. No, my lords, assuming that he was a complainant. A complainant has been held to be permissible for making a complaint to the DCRE. And as a matter of fact, files of the DCRE disclose that there was a complaint before it from the district caste verification, from the Karnataka Rajya Dalita Sangharsha Samiti. A complaint before police establishment is different from appeal before the appellate authority. He made a complaint. That complaint was rejected by the report annexure Z10 at page 472. The outcome of the investigation was communicated to the complainants by the DCRE, and they were also told in that if they are aggrieved by the report, they may file their objections before the DCVC, which is the competent authority to issue validity certificate. They did not choose to file any such plea before the DCVC. Even when this report of the CRE cell was placed before the learned single judge. Their only objection was CRE cell has no right to investigate because there is no reference made to it by the Caste Verification Committee. On merits, they had no substantive objection. No, my lords, insofar as this type of proceedings are concerned, a complainant can at best be a witness, and it cannot be said to be an aggrieved person. Yashwant Boyer produce ಮಾಡಿದ್ದೇವೆ. Yashwant Boyer have you produced? My lord, that is the law declared by the Honorable Supreme Court in Yashwant Boyer, Ravi Yashwant Boyer, which is judgment number 10 in today's compilation that I have filed. It is at page 103. The relevant part of it, my lords, is at para 58, page 130. Sri Chintaman Raghunath Garak, ex-president, was the complainant. Thus, at the most, he could lead evidence as a witness. He could not claim the status of an adversarial litigant. The complainant cannot be the party to the list. A legal right is an averment of entitlement arising out of law. In fact, it is a benefit conferred upon a person by rule of law. Thus, a person who suffers from legal injury can only challenge the act of omission. There may be some harm or loss that may not be wrongful in the eye of the law, because it may not result in injury to a legal right or a legally protected interest of the complainant. But juridically, harm of this description is called damnum sine injuria. The complainant has to establish that he has been deprived of or denied of a legal right and he has sustained an injury to any legally protected interest. In case he has no legal peg for a justiciable claim to hang on, he cannot be heard as a party in a list. A fanciful or sentimental grievance may not be sufficient to confer a locus standi to sue upon the individual. There must be injuria or a legal grievance which can be appreciated and not a strat floration voluntas reasons, that is, a claim devoid of reasons. Under the garb of being a necessary party, a person cannot be permitted to make a case as that of general public interest. That was exactly they want to make out in annexure by page 278. Untouchability ಎಲ್ಲ ಸಫರ್ ಆಗದಿರೋರೆಲ್ಲ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ ಸರ್ಟಿಫಿಕೇಟ್ಸ್. And my father has made 10 crores property. A fanciful or under the garb of a person cannot be permitted to make a case as that of general public interest. A person having a remote interest cannot be permitted to become a party in the list, as the person who wants to become a party in a case has to establish that he has a proprietary right which has been or is threatened to be violated for the reason that legal injury creates a remedial right in the injured person. A person cannot be treated as a party unless he answered the description of aggrieved party. The High Court failed to appreciate that it was a case of political rivalry. The entire case in the complaint and also subsequent events of of the even the anterior events of rejection of my nomination and mention of it in the complaint. The case of the appellant has not been considered in the perspective at all. In such a fact, his complaint filed by respondent file could the most be pressed into service as a material exhibit in order to collect evidence to find out the truth. In the interest case, as all the charges proved against the appellant, the rest of the thing is not pressed. Therefore, my respectful submission is the appeal filed by the complainant is not maintainable, and his appeal was also not maintainable. Then the question is whether revision petition filed or assumed to have been filed by the Rajya Dalit Sangharsh Samiti before the Deputy Commissioner, whether it was maintainable. Because this question is of relevance for the reason the my lord should see the notice issued by the Deputy Commissioner initiating the revisional proceedings, which is at page 275. My lords, ಮಾರುತಿ ಬೋತೆ ರಾಜ್ಯ ಸಂಘಟನಾ ಸಂಚಾಲಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ದಲಿತ ಸಂಘರ್ಷ ಸಮಿತಿ. That is how it is described.
Yes.
In that notice, left hand side, Maruti Bodhe Karnataka Rajya Sangatana Sanchalakarru Rajya Dalita Sangarsha Samiti, described as Arjidararu Akshepanadararu. Then in the body of the then notice opposite parties, Ravindra Swami, Sahakayatru, Tahsildaru, Kandayak Niritru, Gramalik Kadikari. All these are read as respondents. That is why I had to make all of them a party before the court. Then, ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಟ್ಟಿಯಲ್ಲಿ ಬರುವ ಬೇಡ ಜಂಗಮ ಬುಡಕ ಜಂಗಮ ಪದವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು ಲಿಂಗಾಯತ ಜಾತಿಗೆ ಸೇರಿದ ರವೀಂದ್ರ ತಂದೆ ಕಲ್ಲಯ್ಯ ಸ್ವಾಮಿ ಅವರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಘಟಗಿ ಸಂಚಾರಿ ಪೀಠ ಕಲಬುರಗಿ ಆದೇಶದಿಂದ ಬೇಡ ಜಂಗಮ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದುಕೊಂಡಿದ್ದಕ್ಕೆ ಪ್ರಮಾಣ ಪತ್ರ ರದ್ದುಪಡಿಸಲು ಮೇಲ್ಮನವಿ. ಉಲ್ಲೇಖ ಸಹಾಯಕ ಆಯುಕ್ತರು ಬೀದರ್ ಅವರ ಪತ್ರ. ಈ ಮೂಲಕ ನಿಮಗೆ RD ಸಂಖ್ಯೆ ಮುಂತಾದರಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಜಾತಿಯಲ್ಲಿ ಬರುವ ಬೇಡ ಜಂಗಮ ಜಾತಿ ನೀಡುವುದಕ್ಕೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ದಲಿತ ಸಂಘಟನೆ ರಿಜಿಸ್ಟರ್ಡ್ ಬೀದರ್ ಅವರು ಸಲ್ಲಿಸಲಾದ ಆಕ್ಷೇಪಣೆ ಅರ್ಜಿಯ ವಿಚಾರಣೆಯನ್ನು ಕರ್ನಾಟಕ SC ST OBC ಕಾಯ್ದೆ ಕಲಂ 44F ಅಡಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆಗೆ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. Yes. Now kindly see, my lord, section 4F. It can be initiated either suo motu or on an application made to the Deputy Commissioner.
But can we enter into this question at this stage of the litigation?
It can be, because in the earlier round, in the division bench, before the division bench, when I questioned the notice, annexure Y, all that is said is Act 1990 applies. Because my contention was, it is a caste certificate taken for election purpose. Therefore, 1990 Act would not apply. That was the contention I raised. Learned single judge accepted my contention. Division bench reversed it, holding that 1990 Act would apply because the caste certificate issued by the Tahsildar is traceable only to Section 4 capital A. And therefore, against an order of the Tahsildar granting caste certificate, revision petition would apply, would be available under Section 4 capital F. This is the only finding. Kindly see the earlier order of the division bench, which my learned friend appearing for the state relied upon. That is, 338. Page 338, annexure Z4.
Yes.
At 334, that is writ appeal number 65 of 2022. Para 22, page 356.
Yes.
In this context, it is necessary to refer to the scope of issuance of certificate and the revisional powers. Section 4A of the Act deals with the issue of caste certificate and income and caste certificate, and 4C deals with the verification of caste certificate and income and caste certificate. 4F deals with the powers of the Deputy Commissioner in revisional jurisdiction. Then para 23, all the provisions are extracted. 4 pages, my lords may kindly skip. At para 22, page 22, para 24. Reading of the above provisions clearly show that the revisional powers of the Deputy Commissioner is independent of the powers of District Caste Verification Committee under Section 4C. Therefore, remand of the matters by the High Court for reconsideration by issuance of reconsideration of caste certificate itself will not bar the jurisdiction of Deputy Commissioner to exercise power under Section 4F of the Act. Then para 25. Another single judge fells in error, holding that revisional jurisdiction of Deputy was totally barred, hosted by virtue of the orders in the petition, so on. So, then next question is regarding the applicability of Act 1990 and Rule 1992. Relying on the judgment of Chikkana's case, Sri Ravi Patel, the Learned Council vehemently argued that Act 1990 and Rules 1992 apply only to the caste certificates obtained for the purpose of reservation for appointments in civil services and public sector employment and for admission to educational institutions. But Ravindra Swamy obtained caste certificate for the purpose of contesting the elections. Therefore, the Act and the rules are not applicable. He submits that consequently, Deputy Commissioner cannot invoke the revisional jurisdiction Section 4. Rating of Chikkana's case shows that petition they got the caste certificate, etc., etc. Then, at para 28, page 26. Relying on a statement that I had made in the writ petition, that delay in deciding the review petition would affect the prospects of my child studying PUC, it is held that Act 1990 is applicable. Of course, now it is beyond any reproach because in Bharati Reddy, Supreme Court clearly held, even in election caste certificate, validity has to be judged only by the DCVC and nobody else. So that issue has become now academic. But the question is, all that was decided in the writ appeal was 1990 Act and rules are applicable. In respect of my caste certificate, because I have in one of the writ petitions stated that delay in finalization of my caste status would affect my child's education. Nothing else. And of course, again, is this order, then once regarding maintainability of the writ petition, that is at page 29, para 31, it was held that since I have come against a show cause notice, it is premature. Therefore, only issue that was decided was applicability of 1990 Act and rules made thereunder. Nothing more, nothing less.
Yes.
Again, this I went in SLP. My SLP was at page 369.
Yes, yes, we have seen
The
that.
learned senior counsel appearing for the petition after arguing for seeks permission to withdraw this petition with liberty to contest the impugned show cause notice. Accordingly, SLP is disposed of as withdrawn. We make it clear that the show cause notice shall be decided with the concerned authority on its own merits in accordance with law. Therefore, the maintainability of the revision petition at the hands of Dalit Sangharsha Samiti is available to be adjudicated in the present proceedings.
Yes.
Now, coming back to section 4 capital F, it can be, revisional proceedings can be initiated under two circumstances. The Deputy Commissioner may at any time either suo moto or on an application made to him within the prescribed period call for and examine the records relating to any decision made or order passed by the Tahsildar under section 4A or the Assistant Commissioner section 4B for the purpose of satisfying himself as to the legality, propriety of such decision or order, and if in any case it appears to Deputy Commissioner that any such decision shall be modified, null or revised or remitted for reconsideration, he may pass orders within 30 days accordingly.
Yes.
Now, my lords, notice issued by the Deputy Commissioner at page 275 shows that it is not a suo moto proceedings. If it is not a suo moto proceedings, and he treats it as a revision application by the Rajya Dalit Sangharsha Samiti, there must be an application before him. There was no application before him, except the appeal preferred by the Dalit Sangharsha Samiti before the Assistant Commission. he having chosen not to exercise suo motu power and having elected to exercise the power on an application, when there was no application, he could not have exercised divisional jurisdiction.
Yes.
Second aspect is, even if Dalita Sangharsh Samiti had made an application or taking a question whether it could have made an application, answer would be no, because though section 4F does not use the word any aggrieved person, it only says application made to him, by whom it does not say. It does not also say by any person. Therefore, application made to him used in the phrase, used in section 4F can only mean application made to him by a person aggrieved. In fact, my lord, section 96 of the CPC, while speaking of right to appeal,
Yes, we'll consider that.
then no, my lords. One judgment of the Supreme Court is there which interpreted this who can file an appeal as a general proposition. That is Baldev Singh, which is judgment number 9 in the compilation filed today, page 96.
Yes.
Page 100, para 10. There is no dispute that as against a decree, an appeal would be maintainable in terms of section 96 of the CPC. Such an appeal, however, would be maintainable only at the instance of a person aggrieved by and dissatisfied with the judgment and decree. As noticed here and before, the dispute was in relation to a property. The first respondent herein save and accept, making complaints against the appellant and his wife to their respective employers, purported to be laying on or on the basis of statements made by the appellant hearing during cross-examination of the aforesaid suit, had nothing to do with the status of Sarabjit Kaur and the appellant herein as spouses or wife. The locus of appeal to prefer an appeal, for a person to prefer an appeal in a matter of this nature is vital as the right of privacy between two sources. The court cannot enlarge the scope of locus in a case of this nature where the parties are fighting litigations, allegations, etc., etc. Then, my lords, it further holds at para 14. It may be true that a decree obtained by fraud is a nullity, but the question as to whether a decree has been obtained by fraud or not is again a question which must be raised by a person who is interested in the subject matter, because the State Council was repeatedly saying fraud, 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 he repeated, though there is no pleading to that effect. Even to raise a question of fraud, it must be by a aggrieved person. The first respondent in relation to a third party has nothing to do with the relationship into their privacy by present only on one or more grounds as stated. None of the said grounds in our considered view confers locus on the first respondent to prefer an appeal against the decree. Then, para 16. We are therefore of the opinion that respondent one herein cannot be said to have any locus to prefer an appeal. As a logical corollary of the said finding, it must necessarily be held that the learned single judge of the High Court was not correct in disposing of civil revision petition by making an observation which affected the interest of the appellant, and that too without giving an opportunity of hearing. Here, the Deputy Commissioner goes on the basis of the AC report, and AC does not give me any opportunity, and that report is adopted by the Deputy Commissioner. Therefore, my lords, my respectful submission is, in the absence of an application, revisional jurisdiction could not have been invoked when Deputy Commissioner himself is categorical that it is not an application. Secondly, the Karnataka Rajya Dalit Sangharsh Samiti or its organizing secretary has arrived as complainant bar revisionist had no locus standi to file in the application, even if it had chosen to file one. Thirdly, the only material is Assistant Commissioner's report, which has been rejected by the learned single judge and declined to be relied upon on the ground that it was an ex parte report made without issuing any notice to the petition. Now, my lords, kindly take section 4B. Because the complainant invoked this jurisdiction under section 4B when he filed an appeal before the Deputy Assistant Commissioner. First requirement is it must be by a person aggrieved by an order of the Tahsildar. I have already pointed out, reading out appeal page 278, that order of the Tahsildar was not even mentioned. What was mentioned was caste certificate, and I have said that by virtue of law laid down by the Honorable Supreme Court in
point we have noted that it's
my lords have said, and then my lords, I have also pointed out that it was not within 30 days of the receipt of receipt for the order of the Tahsildar. In fact, there was no pleading in the appeal as to when the order of the Tahsildar was received, and appeal was beyond time, even if counted from the date of caste certificate which was mentioned in the appeal. Third requirement under subsection 2 is the Assistant Commissioner may, after giving both parties an opportunity of being heard. No notice was issued, I have pointed out. Then I also pointed out that his power is restricted to allowing or dismissing the appeal and in appropriate cases directing issue of a caste certificate, or as the case may be, an incumbent caste certificate. He had no business to, after coming to a conclusion that it would not be proper to interfere with the caste certificate at this stage, he sends his report. That is totally without jurisdiction. No, my lords, what happens if the report of the Assistant Commissioner is held to be without authority of law? Maybe either delay or lack of absence, this one. Then, my lords, the foundation for the revision proceedings being only the report of the Assistant Commissioner. When the foundation goes, the superstructure will fall without any further ado. That is, my lords, that is the judgment rendered by the Supreme Court in Coal India Limited. I think that was the judgment when I was referring to on at the time when proceedings concluded on the last occasion. That is, my lords, it was given to the court on the loose document I had given on the last occasion.
Yes.
Para 31, 32 of that judgment, I invited my lord's attention. It is a settled law, settled legal proposition that if initial action is not in consonance with law, subsequent proceedings would not sanctify the same. In such a fact situation, legal maxim sub lato fundamento credit opus is applicable, meaning thereby, in case foundation is removed, superstructure falls. Then, my lords, on locus standi, as to, in the matter of caste certificates, who can be said to be aggrieved or who can initiate proceedings. The my lords would kindly take the paper book that I have, the compilation of judgments, judgment number 11 in volume 1, my lords, which had earlier been filed. At page 81. First volume.
Order in?
My lords, that is Ayub Khan Noor Khan Pathan. It commences at page 81, volume 1.
Yes, 81.
81. Paragraph 9 at page 91 of that compilation. Discussion commences. As to who is a person aggrieved.
Yes.
It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the authority of a court that he falls within the category of accrued persons. So this is one, the requirement of locus standi applies before the deputy commissioner also. Only a person who has suffered or suffers from legal injury can challenge the action, action or order in a court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been breach of statutory duty on the part of the accused. Therefore, there must be a judicially enforceable right available to enforcement on the basis of which rejection is sorted to. Thereafter, my lords, what is a legal right is considered. Then para 17 at page 94. Finding recorded is, in view of the above, the law on the said point can be summarized to the effect that a person who raises a grievance must show that how he has suffered any legal injury. Generally, a stranger having no right whatsoever to any post or property cannot be permitted to intervene in the affairs of the other. Then respondent number 5. A respondent does not belong to, etc. That is about the facts in that particular case, it is considered. Then, my lords, at page 96, because this touches upon the manner in which the inquiry has been conducted. Cross-examination is one part of the natural justice in relation to caste status. Here what has happened? Assistant Commissioner records the statements of certain persons, receives some documents, does not permit me to cross-examine and does not permit me to examine any witness. Then, my lords, the next judgment on locus is report the judgment of our honorable court, which is at page 106. This, I think I took my lords through this judgment on the last occasion. Paragraph 7, 8, 9, 11 to 15. Where when the sister was a candidate who was not selected, brother came in a writ petition. This court held that